All right. I think we're ready to get this show on the road, Greg.
All right, sounds good. I'm Greg Moody. Welcome this morning. I'm going to call the meeting of the Tennessee Board of Utility Regulation to order and ask staff to call the roll. Present.
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 Here.
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 Thank you very much. Our first item on the agenda is to read the conflict of interest statement.
The board was created to act for the public welfare and in furtherance of the legislature's intent that utility systems be operated as self-sufficient enterprises. Board members are not authorized to participate in the discussion of or to vote on matters involving entities in which board member has a financial interest, with which the board member has a conflict of interest, with which the board member has a contract of employment, or if there is any appearance of impropriety.
Thank you. Next item on the agenda is to adopt and review of the minutes. The minutes were provided in the packet. We've got 3 sets of minutes to approve. One motion to approve them all. Is there any discussion on the minutes that was provided in the packet?
I'll make that motion.
We have a motion to approve the minutes. Do we have a second?
Second.
We have do we have any discussion on the motion?
Mr. Chairman, I had noted a few typos to Ross. Would they be empowered to just correct the non-substantive typo?
Yeah, they should have already been edited.
Thank you, sir.
Thank you. All right, we have a motion and a second to approve the minutes. All in favor, say aye.
Aye.
All opposed? Motion passes. Minutes are adopted. The next item on the agenda is the public comment period. It is my understanding we do not have anybody signed up for public comment.
No one requested to address the board prior to the meeting.
Thank you. Next item on the agenda is the rules. You should have had a packet of rules handed to each board member prior to the meeting this morning. I believe we're going to have council set to walk us through those rules real quick.
Yes, for the most part, I'm here to take any questions y'all have. Generally speaking, the rules, they cover the definitions that are used in the rules. They cover some provisions, some general authority of the board. They also lay out a procedure to handle customer complaints. The board has the authority to conduct informal hearings of certain matters. And so I have a section dedicated to how we would handle those. We also have the public comment policy we have in place has to be passed under rule. And so that is 1715-04. And then we have a rule governing the Utility Revitalization Fund. As far as the substantive additions, things that we didn't have in previous versions of the rules, I think it's mostly just customer complaints. And so at this point, the rules have been reviewed in office, and I'm pretty satisfied with them in their current form. The rulemaking process would vote to move forward, that y'all would vote to move forward with these rules. I would input, and at that point, we would do a notice of rulemaking hearing and conduct the rulemaking hearing. And then before approval, I would also have ask the Attorney General's office to provide sort of an informal review. The rules would then come back to the board for a final vote. And at that point, they would hopefully be signed by the Attorney General and the Secretary of State.
Very good. Do we have a motion to adopt these rules as presented this morning?
Second.
All right, we have a motion to approve the rules as presented and seconded. Is there any discussion on the rules? And being all in favor of adopting the rules, say aye.
Aye.
Opposed? Motion carries. Rules are adopted.
Thank you, Board.
Next item on the agenda is update on the review cycle.
So, board, this is going to be on page 39 of the PDF that's been provided online. And so those are the entities that have complied with staff requests and board orders And we're comfortable with moving them into the update cycle for us to review their progress moving forward. Ready to release. Board oversight.
Is there a motion needed for that? All right.
Make a motion, we accept staff recommendation.
Motion to accept staff recommendations. Is there any discussion? And being all in favor of accepting staff recommendations, say aye.
Aye.
Opposed? Motion carries.
So next, we're on to the release cases for the financially distressed utilities on page 40. You can see in the list, those are the entities that have complied and have showed enough progress that we feel comfortable releasing them from board oversight currently.
I'll make a motion to accept staff recommendations.
Second.
We have a motion and a second to accept staff recommendations on releasing these entities under financial distress. Any discussion? And being all in favor, say aye.
Aye.
Opposed? Motion carries.
So next, board, these are the entities that have failed to submit the annual information report in the last cycle. And so what we're asking is that by December 31st, they fill out the form. If they neglect to do so, we'll have the ability to subpoena those utilities, the governing body members of management, come to the next board meeting, kind of explain why they can't fill it out. However, there is one addition in the language that was not being used before whenever we did issue subpoenas. And so that's if they manage to complete the annual information report after the point in which the subpoenas were kind of sent out, but before the meeting, we kind of have the ability to back off of the subpoena because they aren't compliant. So that is the recommendation.
I'd like you to add the wording, staff recommendation before.
You're correct. Yeah, so that is
Consistent everywhere else.
Is that
That's
right?
one thing.
dismissed there. Yeah, that is the staff recommendation. You're right.
I'll make a motion, we accept staff recommendation.
Second.
We have a motion and a second to accept the staff recommendations on the annual information report compliance referrals. Any discussion on that motion? And being all in favor?
Aye.
Opposed? Motion carries.
All right, so next we're on to page 42, which is the town of Linville. Board, you may be remembering Linville. They've been under the board for quite some time. The main issues that we've had with Linville are prior management, prior staffing, and, previous governing body officials. However, there are new folks down there trying to turn things around. We as staff are somewhat pleased with the progress that they're making. However, they have a long road ahead of them. They have been, members from Linville have been subpoenaed to come to the meeting because they failed to meet the requirements of their last order. They were required to send us an engagement letter for a rate study to be completed. Previously they were contracted with TAUD to have a rate study completed. However, due to inadequate records and just a whole lot of unknowns with the utility, that rate study was difficult. It was difficult to be completed. So due to so much time passing, by the time the first order was issued about getting a rate study and until now, until the last order was sent, we felt it was necessary to issue a new order to kind of level the ground of where they're heading. So that new order required them to send us a engagement letter, and they failed to do so. And so the members of Linville have been subpoenaed here. And so, board, if you wish to direct any questions or have want a statement from them, they are here. They're representatives, and they're willing to address.
Board, if I can add one thing. The most recent order from the board also required them to conduct a feasibility study into the feasibility of a merger with surrounding utilities. Their previous contract was with the Tennessee Association of Utility Districts, and it's my impression that TAUD does not offer that, does not conduct feasibility studies. And so the engagement letter would have had to they would have had to have an engagement with another entity to conduct that part of the order.
So, and it's also my understanding that Not all of the individuals that were subpoenaed to come to the meeting decided to come to the meeting.
Absolutely. We'd like to hear from the representatives.
Sure.
And I'm specifically curious too, why there were those who chose not to abide by the subpoena, and I wasn't aware that that was a choice, I guess, yeah.
So if there's a representative from the town that would like to, or multiple, feel free to come up here and address the board. Be appreciated. I don't know who wants to draw straws to come on up to do that. Yeah, y'all can, yeah, I'll just let them, y'all just stand up.
Don't mind at all. Thank you. I'm Alton Heathcote with Heathcote and Davis Engineers. We've been hired to help represent Glenville, Tennessee, and try to implement and orchestrate a methodology to get them out from underneath this order and full compliance. There's a number of steps that have already been taken that were part of the order. A number of them have been completed. I have documentation that those have been completed with me today. And if it pleases the board, I'll provide it to Ross. I'll provide the hard copies to Ross. I will also let the board know that since probably mid-June, the city has worked extraordinarily hard to identify, attack, and remedy the issues that were related to the water losses in their system. It wasn't just system-related losses. It also had to do with their billing methodology and the methodology they used related to unpaid bills, which basically were forgiven. All of that has been reversed. As a result of those changes since mid-June, their water loss rate is well below 40% now, and their revenue is positive for the first time in a little while. And it appears that that trend will continue. In January, they will implement their fourth rate adjustment increase that has occurred over a 5-year period. The city recognizes there are still issues that remain and are outstanding that they need to address. Part of our responsibility is to help identify some of those problem areas. We have, subsequent to that, we applied for funds through the American Rescue Plan Act. Those funds have been awarded. Our preliminary engineering report has been approved by TDEC. We're proceeding with the implementation of those plans, which included looping some of the water lines, which were subject to misuse or water loss. I don't know how else to say that, trying to be diplomatic, to build system resiliency and to eliminate the need for putting a lot of water on the ground. We're also replacing a water booster station, which the seals failed in and was the source of a significant amount of water loss. Again, since June, they've attacked the water loss in their system. They've identified 6 major sources of leaks and have repaired those. Again, I'll emphasize that current water loss is well below 40% now, as opposed to, I believe it was 62% at one point in time. So we are making progress. We have a lot of work left to do. We will submit an application for infrastructure planning grant funds to the Tennessee Department of Economic and Community Development. This is probably the one time where we appreciate having an order against the city, because it significantly moves us up the priority list. The items that we will do or implement under the infrastructure planning grant is the construction and implementation of 5 district meters on each of the routes within their system, so that we can monitor and observe the water loss in a real-time level, know specifically targeted areas that it's in, and be able to identify and do the research and field work that we need in those areas to determine what the source of that loss is and attack it right away. They've never had that before. We think that will be a very progressive approach to not only identifying, but also monitoring water loss in real time. There are a number of other initiatives that we're going through right now, but there was Christy Tolley is the city recorder. I'm going to ask her to address the issue about some of the board members not appearing today, although subpoenaed by this board.
Good morning. My name is Chrissy Tolley. I'm the city recorder and also the utility manager. I speak for Miss Patty Patterson. She is a caregiver, mother. There's no one there to take care of her. Is it okay? And then Mr. Ed Bowman, our vice mayor, he's in California at this time. He will be there for a month. Mr. Duke, I cannot speak on his behalf because I do not know, except he had work. I do know that he was unable to take off work. I'm here and Mayor Watt's here and Carrie Reiner is here. She took off work here. Is there any, can I answer any questions or Alton about said it all?
May I ask a question?
Please.
So out of the, I think there were 7 subpoenaed according to the order, is that correct?
Yes.
Okay, seven subpoenaed. How many of the subpoenaed are here?
3.
And what was the primary cause for failure to meet the original order deadlines for engaging people, or what's kind of the explanation? I appreciate the work that you're doing, truly, and the improvements you could make the service to the customers, but what was the reason for not meeting the order deadlines?
I mean, we worked diligently. I had no idea that TAUD, our office had never, unfortunately, like it was said beginning, Limble's been on the bad list for quite some time. So when I come in about a year and a half ago, I had no idea the severity of the situation with the water department. Whenever we got the order, we thought TAUD would send something, had no idea a contract had to be signed. We've had our police officer died, and then we had before that, and one of our aldermen died unexpectedly. A brick wall literally fell on our mayor, almost killed him. So there had been a bunch of barriers on our board itself. And then we had turnover in our office with administration, with a previous city recorder, and then 2 more city recorders on top of that. A lot of billing errors, mistakes. So it was, we would, and then we did have to fire our auditor and hire a new auditor. We got a new accounting firm for the first time. There was just so many barriers and obstacles to even just getting bills and meter sheets because of previous administration in the office. And now I feel like we've caught up with the water department. But we are only open, 3 days a week. And we did, at one time, there was only 1 person in the office, and now there's 2 people in the office. We've have a separation of duties now, so we're making sure that everyone, me and the other lady, Miss Cheryl, that she's helping do different things, and I don't do everything. Finally have a meter reader that's consistent. That's all the reasons that I have.
Anthony, to more generically, I think, answer your question, they didn't have the resources in place to be able to. I'm not sure that the individuals that were there at the time recognized or understood the severity of the issue. You have people there now that are in place that very clearly understand the severity of the issue and have been very, very proactive in trying to get the data in a format where it's accurate and that they actually could submit it in the format that would be necessary for Ross and his team to be able to review it and very clearly understand it and see the progress that's been made. Did we answer your question?
Another comment or question?
Thank you, Mr. Chairman. Oh, thank you. Please say though for the record that subpoenas are not just issued, they issued. Very serious. You can be honored. You serve on the board, being not able to honor a subpoena, be on the board. Say that for the record. I'm interested otherwise, city manager.
Oh, we need one. You live in Linville?
I think in fact, there are several communities where the city recorder is sort of the de facto city manager.
That's kind of what I
Yes, sir.
realize you've only been. I'm not here.
It's okay, I'm used to it.
That's not. But I would. Seems to me it's been just an inability to organize around the problem, start working. You know, it's good news. Hearing from you. I advise you to stay close to
Yeah.
it. But just do this. In government. It was not my choice.
Yes, sir.
Thank you. Any other questions from
Mr.
board
Chairman,
members?
May I ask one more?
You're recognized.
And I guess to follow up, more is maybe a question to Ross. Were the items of the order that didn't get met by the deadline that necessitated this? Did we feel like from a board standpoint, did we not get enough time? Or was it just the time? And I guess, not as eloquently as said, but the scheme itself, I didn't know you had a choice to just not show up. And so, with respect to maybe a legal question, because that is not my forte. What is the board's authority or position with respect to just not showing up to address the subpoena?
The board has the authority to issue subpoenas. That's written out in statute. It's very clear. It's not ambiguous. Subpoenas are not optional. Subpoenas are not invitations. It is an order. And the enforcement for that can goes by directing it to the Attorney General's office, and it's in the courts in Davidson County.
Yeah, I don't like setting a precedent of the community.
Were, like I spoke to Mike, were any of the individuals who are not present, did they get on the Zoom link? Because, I mean, I know that's not the same as being present, but it does show an attempt to
Good point. Very good
be
point.
present as best as you possibly can, especially with the gentleman in California. So is anyone on the, I'm sorry.
I did ask when I said who would be appearing, if there was an optional way for them to tune in online, and I didn't get a response. The response that I received was subpoenas are not optional, and it was important to be here, so they didn't receive a link.
So
I did ask.
Mr. Chairman, I got 2 points.
You're recognized.
Ross, was any attempt made to you by any of these individuals, to be communicating to you or your office that they would not be attending?
So I don't want to speak on that. I'm going to let Megan address that one. Megan's been working with them.
Did any of the members who are not here today, did they reach out to you guys? They did not. Okay.
Ms. Tully provided
Oh.
a list of reasons as to why they would not be attending.
Okay. Second point, you guys mentioned that you've done 5 rate increases over the past 4. Okay. And this may be, I know we're looking at doing a feasibility study and a cost of service study, but Alton, have you guys made some projections on what you look like, maybe the finances will look like from this point forward with some of that activity?
Yeah, actually, Mike, that's a great question. The truth is, we've just begun.
Okay.
We haven't been assigned to tackle this process for only a really short period of time. In fact, Christy called me last week.
Okay. I'm not trying to put you on the spot. I just.
But we have again, we met yesterday so that I could get up to speed on what has been done. And some of the items that were requested that I don't think have been filed yet, we have in hard copy today that I will bring and provide to Ross. I think there were A through G under item 1. Most of those have been completed, and we have them with us today. However, in a longer term answer to your question, yes, we clearly understand that it's not enough just to raise rates. You have to raise rates with a purpose and a justification. So one of the things that we've been tasked to do is to look at what these improvements that we're about to make, how they're going to impact the revenue and expense side of the voucher, both sides of the voucher for Linville, and then reevaluate the customer base, the use patterns, what net effect we think this will have on this continued effort to identify and mitigate lost water. Again, for the first time in a long time, August, September, and October, Linville has a net positive cash flow in their water system.
Mr. Scholes from TAUD would like to answer Mike's question if that's appropriate.
Yes.
I think so.
Sure. TAUD is doing a rate study, and it's probably 80 or 90% complete by now, although we learned there was an additional thing we were supposed to do that was in this order. So just like our other rate studies, it's going to project out financial statements for the next 5 years. They'll be taking into account this newest rate increase that's going to come forward. It'll have a 5-year projection, and if it looks like, rate increases are needed in years 2, 3, 4, 5, that'll be a part of the rate study. And so that's already, like I said, it's probably 80 or 90% done because Melanie got the last information that she needed, from Christie just a week ago.
I will say though, one other important component of that is that we provide Don with what our projected costs are for these capital improvements that we're about to make in our system, so that those expenses can also be incorporated into that rate evaluation.
So there is a 5-year capital plan, or there will be soon?
Yeah.
Okay. So, sorry, no, go.
Mr. Chairman, with respect to the feasibility of merger or consolidation with an adjacent utility, has an entity firm is out, and are you evaluating that as well?
We are, and we've already actually spoken to the town of Linville has 2 water source providers. One is Lewisburg, and Lewisburg is a very, very, very long way away. And we're also involved in that area with the potential formation for a regional authority that ultimately would be the provider for the water source to Linville. The other one, and the long-term provider, is the Fairview Utility District, who in turn buys all of their water from the city of Pulaski, who is almost exclusively the provider for all water in Giles County. We've actually spoken to Fairview Utility District to determine whether or not there was any interest in them playing some role or assuming some responsibility for the management, operation of the Linville water system. And we kind of got an emphatic no, but we've reached out to them again to ask them if they wouldn't mind giving us that in writing so that we could proceed on to whatever the next step beyond that is. Ideally, sorry, Ross, one more thing. Ideally, we make this a permanent fix. The things that are in place and the initiatives are being taken to ensure that Linville has a net positive revenue. Can't call it profit, but a net positive revenue every year. And that their system is in manageable condition, and that they have the mechanisms in place to identify when it's not and what they need to do to fix it. So the hope is not a plan. So the hope and the plan are to put them in a situation where they don't have to come up here before this board anymore because they can demonstrate responsible fiscal management and responsible management of the infrastructure that they own, operate, and maintain. That's the goal with the projects that we've got identified.
Ms. Manisdale, you're recognized.
Thank you. Just a question, has the city of Glenville entered into contract with your firm to complete the rate study and the feasibility?
Yes, ma'am, they have.
Can you explain the timeline to complete that work?
The rate study is actually being conducted by TAUD. The other components that we're assisting them with right now include, we have an ancillary services agreement with them, in which all miscellaneous things can sort of fall under that umbrella, but we're helping them with this process through the ancillary services agreement. But in addition to that, we have the agreement in place for the American Rescue Plan Act project, and we have the agreement in place for the infrastructure planning grant project.
Has the city actually, do they understand the cost of the feasibility study that you are going to be working under that agreement?
I think what they pretty clearly understand is they really don't have a choice. Somebody's got to perform that service for them, and they have to have it done as a condition of this order. So again, we're working basically on an hourly basis to complete that.
Mr. Pelham, you recognize.
Mr. Chairman, I would just kind of piggyback on her question. Could Mayor White, if they're here, could they address that on behalf of the city rather than the consultant, kind of make sure they understand their position in that difference between obviously enterprise fund and a general fund obligation between the utilities and general operations. So I would like to hear from the mayor if that's possible.
Is the mayor willing to speak to the group?
Yes, sir, I do.
Thank you very much. Mr. Pelham?
Thank you, Mayor. Just wanted to request speaking to the understanding of the items that you've engaged TAUD, Heathcote and Davis, and kind of give me a feeling of mayor council position, kind of goals and objectives moving forward, obviously with the order that's there. So just kind of wanted to hear directly from the chief officer of the city.
Yes.
Do you have it? Are there any other questions for us to talk about what's going to be on the staff recommendation? I think that we're getting away from what is the staff recommendation right now. And so I think it's important to stay on the topic of what the recommendation is that we're trying to propose and whether we need to follow up on it.
If that's the case, Ross, staff recommendation was to grant an extension to the order to December 31st. Is that correct? And so with that, I think my feeling too, that subpoenas are not optional. I would move to accept staff recommendation with extending the order, but also refer anyone who failed to comply with the subpoena to the appropriate authority for dealing with that. I'm not sure the proper way to legally say that, Seth.
I can figure that part out. Before we move on though, Edwin Bowman did reach out to me from the utility. Mr. Adams, you had asked about that. He advised he would be in Idaho due to a family emergency. And in response, I told him that subpoenas were not optional, but I did provide the link to join the meeting.
Mr. Chairman, so my understanding, even though that option was given, there was absolutely no attempt to join this morning. Is that correct?
I couldn't speak to any attempt, and it was only Mr. Bowman that I talked to, none of the other absent aldermen.
Could you restate your motion, please?
My understanding of staff recommendation is that we would amend the prior order to extend the deadline to provide proof of the engagement in the feasibility studies from September 29th to December 31st, 2023. All other remaining deadlines will be extended to approximately 30 days or as deemed appropriate by board staff. And then also to refer anyone who failed to meet their subpoena over to the proper authority.
A second.
All right, we have a motion and a second to accept staff recommendations and turn over anybody that failed to show up for the subpoena over to the proper authorities. Is there any discussion?
I don't belabor this, but all right, y'all know me, I'm pretty much cut to the chase. Seth, what happens if we do that? We turn that over to the Chancery Court in Davidson County. What do they do?
Honestly, I couldn't speak to what the Attorney General's office would do or and
I
would
mean,
have to
is
speak
there,
for
is there a penalty they pay, or is it just, hey, you guys gotta go to the meeting? I mean, what are the repercussions from turning that over?
There's potentially a penalty. Essentially, not abiding by a subpoena can be considered contempt of court. And contempt of court, the punishments for that are left up to the judge. And so it can include being required to attend if it's a situation where someone's attendance is needed in the future. It can also be take the form of fines.
Okay, I've got a suggestion. How about if we amend your motion and say, okay, when do we meet again?
We haven't scheduled another meeting,
Okay.
but we're looking at more.
You either come to the next one or we're gonna turn it over to the Attorney General. Would you be,
I'll speak to that. My concern with that is we're setting a really very bad precedent and right out of the gate for this board. And the first thing we're saying is, you don't have to come and we're going to give you a 6-month extension.
that's reasonable.
I appreciate your point, but I would leave my motion as it is, just due to the authority of staff for when they send it out. You know, it's not, I don't know that it's an optional request. It's not a request.
The subpoena said if the subpoenaed individuals do not comply with the subpoenas, we will refer this matter to the Office of the Attorney General of the state of Tennessee. So they were properly warned.
Just a suggestion.
Any additional comments? All right, we have a motion and a second. No further discussion. All those in favor of the motion?
Aye.
Opposed? Motion carries.
Too soft. I mean.
All right, moving right along. You know, I said at the beginning that this was only going to be a 2-hour meeting. I think I lied to all y'all. If we keep up at this pace, y'all. Okay, so the next thing that we're moving on to is on page 65, and this is a customer complaint in regards to the Madison Suburban Utility District. How staff recommends that we go about hearing this complaint forward is that first we'll hear from the complainant. And staff recommends that the complainant gets 5 minutes to discuss what the complaint is and their position, followed by potentially questions from the board, and then turn it over to the Madison Suburban Utility District, and they will have 5 minutes to present as well, followed by questions from the board. Seth, do you have anything to add in regards to the customer complaint process, or are we good to just get started if the board is amenable to what I just saw?
That sounds fair right now, especially since we don't have any clarification to how it should be handled at the moment.
All right. So, Chairman, if that's amenable to you, that's how I would recommend it.
Please proceed.
So there's a representative of.
Morning, I'm John Cooper with the law firm Holland and Knight, here on behalf of Greystar Real Estate Partners. We are here appealing Madison Suburban Utility District's denial of a variance from their new district system development fee. It's important to note that we are not challenging the authority of the district to enact the fee or to take whatever actions the district needs to take to support the system. We're simply challenging the denial of the variance based upon the fairness and transparency of the process. I'll quickly go through the history of how we got here. Greystar is constructing a multifamily development on Gallatin Pike in Davidson County. They began their due diligence and rezoning of the property in 2022. On March 20th, 2023, they received approval from the utility district to connect to their water system with a tap fee of approximately $47,000. This amount is what Greystar used for budgeting the acquisition and financing of the project. So for acquiring the property and financing the project. The seller of the property delayed the process because the seller filed bankruptcy. And so my client had to wait to get the permission of the bankruptcy trustee to sell the property, which they did receive in the summer of 2023. On July 14th of 2023, Madison Suburban sent a new invoice that was $263,289 higher. It included a handwritten note at the bottom that said system development fee. This was apparently enacted in late June 2023 and became effective July 1st, 2023. We have been unable to identify any public notice about the fee. We could not find the agenda online. We could not find any way to know that this new fee was being considered. The response that you will hear notes that on the bottom of the invoice, it says price is subject to increase if not paid within 30 days. So it was not paid within 30 days because of the bankruptcy and them not being able to acquire the property. But we would note that the tap fee for which the invoice was issued, that price did not increase. What increased was a new fee that was completely separate that we were unaware was being considered. Like I said, they would have paid the original invoice even with this bankruptcy pending if they had known that they were going to be subject to a five-fold increase in what they had to pay to connect. They detrimentally relied on the prior amount and prior approval, and there is subsequent correspondence between their engineer, Kimley Horn, and the utility district during this interim period about the initial fee and the size of the lines and that kind of thing. And there was never any mention to Kimley Horn or my client that this new fee was even being considered. So we're not challenging the basis of the fee. We just think that the utility district should honor its prior approval under the prior structure of the tap fee. So we're asking the board to essentially overturn the district's denial of our variance request from this fee. We do have Matt Evans with Greystar here if the board has any specific questions from the developer. But again, we are not challenging the fee itself. We're just challenging the application to this project based upon the history. Thank you.
Thank you. Do we have any board members' questions?
Mr. Chairman, I have two questions of Greystar.
Mr. Pelham?
Number one, has Greystar ever,
Sorry.
has Greystar ever had any prior projects or principals of Greystar had prior projects with Madison Suburban? One question. Number two, I think in reading the closing on the property occurred in late May of 23. Why was the payment of the 46,000 change not made then within 30 days of closing on the property?
Mr. Evans with Greystar to respond.
So first question, do we have any other projects in Madison Suburban Utilities District? We do. We have an adjacent project that is under construction at 110 1 Mile Parkway. And the question is to whether, second question was the timing of payment after post closing on the land was just a procedural process, but it takes time to get through an invoicing process. If we did not put that invoice in particular on the closing statement, so it just took some time to work with the system.
Any further board members' questions or comments? Thank you.
So now if there's a representative from the Madison Suburban Utility District.
Mr. Chairman, members of the board, I'm Rob Wheeler, and I'm the counsel for the Madison Suburban Utility District. They go by MSUD. I prefer to refer to them for our discussion here as the district. The chronology of event, first of all, Mr. Colonna gave us until yesterday to file our response. We filed it the day before. Have you all had an opportunity to read it and digest it? The chronology is that the plans were first submitted on February the 27th. On the 15th, the district sent to Greystar the notice that their plans were approved. On the 19th, Greystar learned that the owner had filed for bankruptcy. On the 20th is when Greystar received approval from the district with the $46,000 some bill to pay the fee. And the notice did in fact say that prices subject to change if fees quoted are not paid within 30 days of quoted date, or if product prices of supplier increase. And from the 20th, they were not paid. Greystar became the owner, as has been pointed out here, became the owner of the property on May the 20th. And they were, that original fee was not paid by June the 20th. And they were obviously at that point, there was no bankruptcy obstruction involved as far as Greystar was concerned. It was at the June meeting that the district then considered what they call the system development fee, a very common fee that is charged by other districts, usually referred to by others as a capacity fee, and then short on a 292 unit development, the fee is based per unit, which pertains to the actual usage that's being used. And that is something that the district had never done. And there's a comment in the letter to you from Greystar asking for this appeal, that there was no nexus mentioned, which is of course a connection between the fee and why is it necessary? Well, unless you live under a rock, you know tremendous development that's going on in East Nashville to the Sumner County line. This alone is a 292 unit development. I live in Goodlettsville. There's another huge development going on there behind Tyson Chicken, and they're all over the place. So the connection is the stress on the system and the growth in the area. But even after June 23rd, and we finished that at the end, in the June meeting, this fee was proposed to meet that demand. And it passed, and the board said it should become effective July 1. Greystar had, as of June 23rd, they had 7 more days before that fee became effective. And they still didn't meet the mandate or of the 30-day period to pay the fee, even though that was beyond 30 days. Had it been paid, I submit to you between June 23rd and July 1, an appeal, if the board had enforced it, the appeal may very well have gone the other way, but I'm speculating about that. But it wasn't until they received notice
of the system development fee in July. Then on July the 14th, they received notice on July the 14th of the new fee, and they paid the $48,000 on July the 18th. And as has been mentioned by Mr. Cooper, it is a matter of fairness. And I submit to you that that is in the law, as my response said, that's called equity. And there are therefore maxims of equity that come into play. And that is that delay defeats equity. Equity aids the vigilant, not the indolent. And equity looks to that to be done, which ought to be done. All they had to do was pay the fee within 30 days of the time they got the notice, even up until June 30th. It is our position that it is the board's responsibility to provide water at the and be financially responsible. It's your responsibility to see that the district just does just that. I think both our board and your board are doing just the same, doing that, if in fact why.
Mr. Wheeler, your time's elapsed.
I understand.
Mr. Turkey, you're recognized.
Thank you, Mr. Chairman. Mr. Wheeler, I read your response, and you're not suggesting that they're being punished for missing the deadlines, are you?
Not at all. Just everybody meet their responsibility.
Well, you do say, though, if they had met the deadline, they probably would not have had this fee. Is that fair to say?
Well, I think so, but the board passed their system development fee to become effective July 1, and it wasn't even done by that, the approach of that new fee.
I understand, but is it fair to say, had they paid the $46,000 within the 30-day period, they would not have had this fee?
I submit that our board would probably have accepted that, but I'm just their lawyer. I can't make that call.
I understand. Understand.
I can answer that if you'd like.
This is Jim Wade, the operations manager, who was all about the system development fee.
Gentlemen, ma'am, so the answer to your question, sir, is if the invoice had been paid prior to the 1st of July, no, this additional systems development fee would not have been applied because said fee did not exist until the 1st of July.
Mr. Newman, you're recognized.
Yeah, I have a couple questions. First is, are there other developers, contractors in the same position where they were quoted prior to this development fee and now are going to be subject to development fee? Are they having to do the same thing?
Yes, sir. So at the point of the approval by the board of the system development fee on about the 1st of July, I then went back, correlated which developments and projects had approved plans that had been greater than 30 days old. I then reapplied the system development fee unprofessionally, but expeditiously to get that information to the developer's contact, in this case, our engineer firm. And so between early May and the 13th of July, I had zero contact with their engineer. The first correspondence with their engineer was on the 13th of July with system development fee.
So, yeah, the second question is, so you had a list of people that had projects approved prior to that. So you didn't notify them, let them know, hey, there's fees going to be hit?
I did, yes, sir.
Okay.
100%, sir. Predominantly via email.
Mr. Giles, you're recognized.
So my understanding, this organization was aware of these fees that would become effective July the 1st.
They were made aware after the fee was approved by our board. So yes, sir.
So then you all gave less than 7 days notice on this type of a fee change. I'm all for capacity reservation fees, but when we did it, we gave 6 months notice to everyone so that they would have time to plan. So my understanding is at a board meeting, you all approved this and then roughly 7 days later implemented this. And during that period of time, you all notified
this group that there would be a new impact fee. Is that correct?
7 days.
In that 7 days?
It was actually 3.
3 days? Okay,
27.
I'm sorry. I've rounded up.
So to answer your question, which I believe is, did we notify them prior to the going into effect? No, sir, because the effective date was soon after the approval.
And so do you all feel it fair and reasonable that the development community as a whole was not notified of these fees when you had a list of developers who were working toward growth in your area? I'm questioning the fairness and reasonableness of this.
I understand your perspective and your question, sir. I don't have a straightforward answer, but I do know that the 81,000 people that we do serve in our population, it's not their burden to bear.
I completely agree with you. I serve 100,000 people and I gave 6 months notice when I put the capacity fees in place because of fairness and reasonableness. That's my question.
Mr. Perky and then Mr. Pelham.
Thank you, Mr. Chairman. I understand that you implemented the fee now. Mr. Wheeler, earlier when I said, was it put in place punitively? I understand the timeline now. Was there no discussion of grandfathering, or was there no discussion by the board of it being effective July 1st for projects after July 1st?
I don't recall the specifics of that particular meeting, if that particular topic was discussed. When we did discuss when it would become effective, hence the date of July 1st, didn't discuss grandfathering in. To my recollection.
Mr. Pelham.
Just one other question similar to that. With other fees, whether it be tap fees or rate increases or things that have happened that way on prior rate increases, has that been standard practice for the district to adopt them or modify rates and fees on say the 27th of the month or whatever that was, and then 3 days later they become effective with limited, if any, notice?
So when it comes to utilization fees or rate.
Any other fees that y'all normally would review and adjust for fiscal responsibility, is that typical, that short of a turnaround?
Generally, it's our practice that we provide, if it's a ratepayer increase, we provide at least a 30-day notice.
Mr. Hampton.
So was this SDF, was it discussed at any other meetings prior to this one? Because based on the attorneys, the timeline, it says it was first discussed and voted at this one meeting. Were there prior meetings where you brought it up, so that you could get public notice? So you could say, hey, we're thinking about this for public comment, or was it just brought up at the meeting and voted at the same meeting?
The short answer to your question, sir, is we developed this and did a case study and figured out what would suit best for MSUD, and then we provided that recommendation to the board for approval.
But the board, based on the timeline, the board's first discussion was the June 27th meeting. Yes, and no, they had never participated in the discussion prior to that moment. But I'm not saying what you may have communicated, but it's not, that was a first public discussion.
Yes, sir.
And only. Okay, thank you, Chair.
Any further board questions? Thank you.
Yes, sir.
So now at this point, board, I don't know if you have any further questions from the folks involved from either party. But I think at this point, Seth, if I'm correct, they have to make some sort of finding. Is that how we? We've never really done one on this board.
To my knowledge, at this point, we don't have a specific requirement, but that is probably what should happen. Is there should be a finding and then a recommendation or an order implementing the decision.
Mr. Pelham.
I actually have a legal question. I'm not an attorney, I'm an engineer. From my understanding, utility boards have full right and authority to set rates and make them adjust them and make them effective as needed for the benefit of the utility district. But are there any formal public notice requirements with respect to Tennessee state law? I would think there should be better customer service and give longer notice to do that, but is it legal? There's nothing illegal that's been done to knowledge, I guess maybe a better way to question. phrase the question.
To my knowledge, no, but I don't know that I would know if there was a specific notice requirement. Under the Open Meetings Act, there has to be adequate public notice of a meeting, but for a utility district, there's not a requirement to publish an agenda ahead of time.
Mr. Giles?
So can we rule on fairness and reasonableness as we see that in this case versus legal?
Give me just one second. So the board's jurisdiction here would be the justness and reasonableness of a utility system's rates, fees, or charges. And then as far as the remedies offered, the board may order such remedial action as necessary to address the customer's complaint, including the exercise of any authority conferred upon the board by this part. So given the jurisdiction, the justness and reasonableness of utility systems rates, I would advise exercising that with caution, but I think that is within the board's authority.
Discussion.
3 days notice isn't much. Certainly to have a brand new impact fee that, especially $250,000 to an invoice that's been sitting there since March, the other known issues.
And my struggle is you've had to spend months developing this fee, so why not communicate that out? Just I get back to this fairness and reasonableness of, I agree with the impact fee. I think every system in the state should have one. But the way it was initiated that's a struggle.
Minimum of 30 days. When they sent the notice, they handwrote that fee on there with no explanation.
They even
of course they were shocked. Any reasonable person would have been.
Yeah, they just literally marked through the March 20th invoice and just wrote another $307,000 or $310,149 under it, and there was not even a new invoice generated.
So
You guys think about sending a persuasive letter to the board, asking them to consider reevaluating their decision based on fairness and reasonableness. Maybe it's our opinion, it's supposed fair or a reasonable amount of discussion before it came into play, rather than exercise the authority to just revoke decisions. That's a good thing to consider.
I don't like the fact that they would normally give 30 days for most other rate changes and impacts, and then this one just pass it on the 27th, effective on the 1st, and no other
You can't
notice.
change a customer's bill in that short amount of time. The billing software.
And
ready
to,
for that change.
and to Nick's point, though, they had a list of developers who they knew were
To be impacted.
impacted, and there was no, I mean, it's an hour-long process to let each of them know this is coming in 3 months or 2 months or a month even. That's my struggle with the fairness.
You had a list, you could have at least said, hey, July 1, this is gonna happen, y'all might want to pay a fee.
You know, you could at least grandfathered in those. You could have done some other things other than just 3 days notice.
I like to, better responding to the board, mainly because this is bigger than this one entity, and I would prefer not to have, if we move or make it narrow with this entity, we have 3 or 4 come back up here, and we have the same discussion, only to tell the board the same thing. So I would like it to, whatever we decide, it has to be something that would encompass everyone who should have known, you should have been gotten prior notice prior to July 1st.
And for the record, my impact fees were challenged and actually heard in front of UMRB, but I gave 6 months notice and there was technical rationale for everything we did. Therefore, it was correct. That's.
Where else do you find this kind of fee immediately implemented without any notice?
It was a long time ago. I know counties do development fees and that, but I've seen back years ago, it would be very immediate. But that's if that would be anybody who hadn't already provided notice. It would be new people, right? Whereas this one is not new. So, I would probably not. At least provide a list or I don't know, about 6 months or whoever was on the list before July 1st, have a chance to get the fee reconsidered.
Sure. Respectfully, though, precedent, if it's not specifically required in the law that says, hey, you can't, just because it's rude, because it's maybe bad, unprofessional, or seemingly not, whatever this precedent is, it could conceivably be challenged for, so I mean, what do we do? I want to have a legal basis for what do we do, whether that's an order requesting justification why there wasn't notice or some response as to why you give 30 days on some fees and only 3 on another. I mean, that's where I'll guess maybe some guidance on the legal authority we have instead of, I mean, we're almost asking, hey, please don't do this because we think it's bad.
Well, that doesn't, I feel like kind of to her, my interpretation of her point is we're not forcing them to change. We're just saying that we think this is bad. So it keeps us from, that's the, please play nice versus you have to hit them with a stick and say, do it. So,
well, even if they consider a reduction in the fee, but to hit for $250,000 that they didn't know was coming, I could see, I don't know what percent reduction, but
I don't want to recommend the level.
Board, an option y'all have is you could try drafting the letter and asking them to reconsider their decision, but then reset this for the next meeting. That you'd retain jurisdiction. If there was no action or the action was unsatisfactory, this could be heard again. And y'all could discuss.
Reconsider everyone on the list.
Yeah, I'd like to know the scope. I mean, how many we're looking at.
I think that's a pretty good option as well. It gives us time to familiarize ourselves with exactly what has happened here.
So to be clear, what we would be doing is you'd be requesting staff to draft a letter addressing what the board's position is on the matter, in that it's unprofessional, and really not just a good way to do business.
Did not provide adequate notice.
Did not provide adequate notice, especially in terms of how they provide notice for how their rates are changed. And that's different than this practice. And then also, we can reset this matter to be heard at the first meeting in 2024. If they choose not to go back to what the previously, like, let's say that they agree with us and they go back to what was previously initially the original fee. If they go back to that, would you like them to still come in front of the board? So assuming that they don't go along with our letter, then we'll reset this matter. But if they go back to what the original amount was, then we'll let it go.
For everyone on the list.
For everyone on the list. But if not everyone on the list was positively affected, then we'll bring this matter back.
Mr. Chairman, I do worry about that being 5 months away. What about the developers? I mean, are the developers going to proceed with the project based on this looming, with no decision? I like what you're willing to do. Will the developers just leave the project? I mean, I know it's not a concern of the board, but it should be a concern of the utility district. I mean, I know we can't do anything before the end calls, but.
Board, Mr. Wheeler would like to address the board if you find it appropriate. 4 of the 11, what it was?
18.
4 of the 18. So 4 of the 18 have already paid.
System development fee, of course, not the same amount.
They're different size projects. So.
I'm sorry, I'm gonna ask for clarification. The 8 4 paid that were quoted prior to the July one day and now paid the fees. Are you talking about 4 paid total?
So of those particular, around 18, 4 of them have already paid in full. And again, they're all varying levels based off the scope of the development or project. But yes, 4 more.
I'm sure I didn't feel like you answered the question. Was these developers, but that were before July 1st? So 18 developers for July 1st.
So we're approved.
They were approved or gave tentative approval, and then they paid after July 1st.
For clarity, these 18 had approved plans by MSUD prior to, a lot of them prior to June.
Okay.
Fee was enacted on about July 1st, or July 1st. They received a new invoice, and then that was 3 months ago. Since in that past 3 months, that 3 months before the new invoice.
It was after July.
Is 18 a typical number that y'all got holding? How many jobs are out there? Is that a large, y'all say it's really growing there, and I understand that. Is that 18, is that, y'all usually have 18 sitting out there waiting to pay fees, or 30, or, I don't know if that's my question right. Is that typical for you guys, or is that a lot more than you typically have?
Since I've been here in a short amount of time, we started tracking individual projects and plan approval. So since last October, November, there are over up close to 3,000 units.
Okay.
In various stages: planning, construction, and approval, financing. Whatever.
Of the 4 that's paid, what was the largest system development fees?
I don't know off the top of my head, sir.
For discussion.
One clarifying question, just if we rule against the utility, what is their next step? Chancery Court?
I would have to verify, but I believe it is Chancery Court. Yes, sir.
It would be helpful. Text about our feelings about it, because they're getting information from their staff. They're in a situation where growth is all around them. Lots of things are going on. It's easy to reach out and get a little bit more money because everybody's wanting to build. It doesn't take away from the fact that it is fair to not provide more notice and not provide more public discussion. And I just be very cautious before I move against a utility when the fee itself is fine. It's just, it seems unreasonable to us that they didn't provide.
Right, and that some have paid already is a new dynamic too to think about.
So I understand Greystar, their challenge is not to the fee or that it exists.
It's the amount.
It's a request for the variance request because it was effective July 1 and they hadn't paid yet. And had they paid 2 weeks prior, if the fee wouldn't have even existed, they could have paid their $46,860.
So based on the feedback that I'm getting from the board, I'd like to provide a recommendation, just to kind of facilitate the conversation of how to proceed. So staff would recommend that we do send the letter that Ms. Vanisdale mentioned earlier. Also, order board staff to essentially generate a report about what transpired to get more information about who these other developers are, how much money is outstanding, so we can really understand the scope of all of this. Part of that will possibly have some sort of determination from legal as to what extent our authority can go here. And last, reset this matter for the first meeting of 2024. However, if after we send the letter or sometime in between, if they, just go back on everything and say, these 18 developers, we're just going to reset to what the original fee was, the 4 have already paid, we're going to refund whatever that difference is. If they correct the problem that we're identifying currently, then we're just going to drop it. Is that, so that's what staff would like to recommend for y'all to.
Mr. Chairman, I'd like to move to accept that recommendation with the inclusion of one question in that, Ross. Just a question to justify why normally 30 days given for most other rates and why only 3 for this.
Sure.
So, recommend.
All right, we have a motion and a second to accept staff recommendations. Any further discussion? Convene. All those in favor? Opposed? That motion carries.
All right, so next, this is probably the most exciting thing that we have going on at this meeting. On page 128, I'm very excited about this. We're going to be talking about the potentially first disbursement from the Utility Revitalization Fund. Board, if you recall, that I've mentioned to you all before, we have $2 million sitting in the Utility Revitalization Fund that can be used in the case of mergers, whether they're board-ordered mergers or mergers that the utilities are pursuing on their own. However, a merger has to be in pursuit. So for a long time, we've been dealing with the city of Wartburg. Okay, the city of Wartburg has had a struggling sewer system for a while. Plateau Utility District so generously is willing to take over the Wartburg sewer system, and as a matter of fact, has been pretty much managing and operating it for more than a year now. So the Plateau Utility District, in the process of merging with the city of Wartburg, they are requesting $1,172,722 from the Utility Revitalization Fund. That's going to be retired the debt from Wartburg and 5 payments of $69,000 roughly paid annually to the Plateau Utility District to cover the cost of Wartburg's depreciation. Board staff is not comfortable with giving that amount of money out because, not to say that Plateau isn't deserving of it. If we had more money in the fund, I would 100% fund that entirely because what they're doing for the community out in Wartburg goes above and beyond what their call for public service is. However, in working with the Plateau Utility District, what we find to be amenable is instead $500,000 total. We would like to provide $300,000 one-time upfront to the Plateau Utility District upon completion of the merger, and then a series of $40,000 over the course of 5 years to help cover that depreciation expense that's coming from Wartburg. And so each of those payments will be made within, first payment will be made within 90 days that we know the merger is complete, and the subsequent payments will be made every 90 days after. And essentially Plateau just needs to continue to work with board staff in us making sure that we get the necessary documents to make sure the money is being spent correctly. So with that being said, Mr. Mike Monroe from Plateau Utility District is here, and Ms. Betsy Knotts as well, serving as counsel. If y'all find it appropriate, Mr. Monroe can come up here and speak, or if you have any questions.
Yes, please.
Did you have, my name's Mike Monroe. I'm the general manager at Plateau Utility District. I don't know if you have questions or if you want me to give you a narrative history of how this developed. Did you have questions specifically? I sent you all some information beforehand because I had tried to put myself in your shoes and say, what would I want to know if somebody asked me for over $1 million? And I would want to know, if I were in your shoes, had they thoroughly thought it through, or were they going to waste my money? And that's why you have the binder there. It projects it out 5 years. I feel like I've been conservative on the revenue side, which maybe I shouldn't tell you that because then you might not want to give me the money, but that's what the money's there for. That's what it's there for. And there's a movement afoot within this industry, is my belief, for more of these. Why? Because so many of the small ones are failing. And I agree with that movement. I'm not happy to be the guinea pig of it all. We never wanted a sewer system. I went back and reviewed the Tennessee Association of Utility Districts evaluation of this, and I think the world of Don and John Hall, but to say that we were excited about, or however the verbiage was wouldn't be exactly what I'd call accurate. But we are willing to do it, and we do understand that it's best for our community. We do understand. This is a movement that's afoot within the industry, in my opinion. You all have expanded authority. I don't have to tell you that. It's weakened my negotiating position because I was ready to walk away and say, hey, you figure this out. You've got expanded authority now, and you know that with the law that passed July the 1st. So what I tried to do was be very thorough in my evaluation to show you that I'm really confident in the revenue numbers. I'm moderately confident in the expense numbers to show we can turn this thing around and it can be financially self-supporting. So with that, I'd love for you guys to give us my ask. It'll make it easier on us. I understand for Ross's position of not wanting to give away over half of the money that you've got. And the first time that you've ever given any away, I understand that. I think we can be successful either way. So if you have questions specifically, I'll be happy to try to answer them.
Mr. Pelham.
Mr. Monroe, who are the debt holders of the 825,000? So who holds those pieces of debt? And then two, if as staff recommendation were less and you were still left holding debt, do you feel like there would be additional rate increases necessary to subsidize that debt service?
So
if you didn't fund to pay off the debt?
Answer the first part of that, and Betsy may correct me because she's more of an expert at that than I'm not an expert at it, but it's my understanding that most of that are USDA bond issues. The one that we didn't ask to be retired was the state revolving fund. So that's the first part of that. The second part you asked, will there be additional rate increases? I don't think so, but you can never guarantee that because it's my board's responsibility and me as their manager to recommend to them appropriately that if all of these projections are incorrect, we'll just have to be more aggressive. Because I can assure you the one thing I will not support, because I'll follow orders if my board votes that way, I will not support propping up a failing sewer system with revenues collected from water customers, who most of which don't receive a benefit from that sewer system. There's about 520 sewer customers and we've got 4,500 water connections. So, you know, you've got 4,000 customers that receive no benefit. I can't go along with that. But I do think that the rate increases that you see in the notebook are, nobody's going to like rate increases. We all know that, but those are pretty moderate in my opinion. It inches them up over 5 years. I believe that they're adequate. If we have to be a little bit more aggressive, I don't believe that it will be drastic. Does that answer your question?
It does. And I have one more, Mr. Chairman. If this board accepted staff recommendation at the lesser amount than requested, I realize it would still have to go back and be ratified or approved through your board to proceed with merger or consolidation with Wartburg. Do you think that's going to be an obstruction, or would they see, yes, we recognize it's at the end of the day, we're serving people, right? We're providing service. So you take that on head on for, as you said, a failing utility that's adjacent to you. But is that going to be a sufficient support to encourage Plateau to move forward?
Well, I do, and I'll tell you why. And I hope that I've had a lot of conversations with Ross. It's been excellent to work with. You all are fortunate to have someone like him working for you, in my opinion. And Ross has been very candid with me. I appreciate that. Appreciate a straight shooter. And he said, Mike, I'm not going to recommend that. And we talked about what he would be willing to recommend. And I called him and said, hey, I don't want to do an end run around you. I want my report to reflect what my ask was, not what you said you're willing to give. And he said, it's fine with that. I've talked with my board about that. It's not going to obstruct this thing moving forward. Betsy and I had a discussion when we came in. If this goes good today, we want her to forge ahead. We want to try to get this thing done by January the 1st. That answer your question?
Yes, sir. Thank you.
Thank you.
Mr. Newman.
Ross, just, you were saying the $2 million over what time period is that?
So that we have that 2 million until the legislature decides to take it from us. We don't get any more. Like, it's not a recurring thing. So we just have 2 million sitting in there.
Right. And then do you have any others you're working with right now who are looking to use these dollars?
There's no one as close as these guys are, but there have been other utilities that are interested, that I think are also worthwhile projects, but there's no one as guaranteed as this one.
Thank you.
Any other questions?
I move to go to staff recommendation. Wish we had 20 million in that fund instead of 2, because I know how expensive things are, but.
Or they were going to recharge and give us more money so we could do a lot more with it.
If we have some success stories,
That's
they may do that.
If I could address that, I think that we're, your all success at getting additional money track along with our success of turning this utility around. Because if you can invest those dollars and we turn this around, and Plateau's not the new Wartburg down here suffering to beat up by this board, deservedly so, I would think that would speak well for you as you all build the case to ask for more money. So I didn't mean to
We have a motion on the floor to accept staff recommendations. Is there a second?
Second.
Motion and a second. Any further discussion? None being, all those in favor? Opposed, motion carries.
Thank you.
All right, board, next, we are moving on to City of Mason on page 145.
Chairman.
Hey, Ross, I think the board is desiring a 5 or 10 minute break.
Let's do it.
And can I just, I'm probably out of order, whatever the right word is. Anyway, I'm Jennifer, I work in the comptroller's office, but board, it looks like this is gonna be another long one, like we had the last time. So, we are gonna put out some snacks for, you all and whoever else. I know, I was just sitting there thinking, oh no, not a bunch of growling stomachs again. So that's perfect. Y'all take take your break. We're gonna put some stuff out for you and,
Thank you.
you're welcome.
Jennifer, I already wanted some idea to eat before.
I brought Mentos, yeah.
We are at recess until 11:40.
All right. All right, we are approaching 11:40. If everyone could rein it back in so we can get started. And Chairman, I'll leave it up to you to call us back in when you're ready.
We are back in session. We are out of recess. Back to you.
All right. Okay, board. Next up, we have the town of Mason. So y'all on this board should be familiar with the town of Mason. They've been in front of us a few times. However, the town of Mason received an order after the last T-board meeting due to many issues. The main issue that was highlighted was their failure to have a licensed operator consistently on staff, in which TDEC was highlighting the issues that Mason was experiencing because of their lack of a certified operator. So Mason has been doing a whole lot here recently to improve the situation. One of the things that they did in order to comply with the requirement of having a licensed operator is they have contracted with the Alliance Water Resources, which that started back on October 16th, I believe, board. And during this short amount of time, Alliance has made many positive changes for the town of Mason's utility. They provided me with this prior to the meeting. They found issues with the wastewater treatment plant currently not discharging. They found out there were issues with the fluoride and chlorine feeds. There were issues with lift stations that weren't running properly because the breakers were turned off. They've done a whole lot. They fixed 11 water leaks, all in a very short amount of time. So we are very pleased with that. Mason is currently looking at trying to get some state revolving fund monies. Unfortunately, they're really not financially capable of taking on some new debt from SRF based on the feedback that I've gotten from TDEC, which is problematic. They are working on a rate study currently, and that's underway. So hopefully that will get their finances looking better so they can start taking on more debt to make the changes necessary for their system. They received some ARP money through the county, which is going to be used to address their issues. But the issues from TDEC mainly stemmed from their last sanitary survey, and just finding plenty of issues throughout the system that Alliance Water Resources should be taking care of. However, the town of Mason, the would-be manager, but there wasn't at the time in which these subpoenas were sent, and the governing body of Mason was subpoenaed to attend this meeting, okay? At the last order that was sent to them said that they had by September 1st to comply with the order to get a licensed operator employed by the town. I had conversations with the mayor because there was desire based on, some recommendation personally that they pursue what a lot of utilities do in Tennessee and to look to their neighbors for help. And so they were in the process of working with the Poplar Grove Utility District. However, there was an issue in trying to get some sort of memorandum of understanding that they were going to vote on the matter by the end of the month, that the Poplar Grove Utility was going to vote on the matter by the end of the month. And we only got a half-signed MOU midway through September, well after the September 1st deadline. The other part of that order also said that if you fail to meet the September 1st deadline, you also have to get a feasibility study started with someone. It is my understanding that the town has not began pursuing that, and perhaps they don't really want to pursue doing that feasibility study into a merger with the surrounding utility. So I currently don't have a recommendation to offer here, board. The only recommendation that I could offer is if they are persistent that they will not pursue feasibility study, that, you know, we have harsher consequences, or if they choose to not do so. But otherwise, the representatives from the town are here. If you would like to address them directly and ask them questions about the current state of the utility or anything going on. So I'll leave that up to you.
I think the board would like to do.
Yes. So would a representative of town like to, or representatives, that's.
Thank you.
Thank you, Chairman. Thank you, board members, for having us. And if we're here to answer any kind of question. And we here, my name is Eddie Norman. I'm the mayor of Mason. And I have city recorder of the city of Mason, and I have Mr. Evans from Alliance Company. And we'll be glad to answer any kind of question you're concerned about.
Members?
And board, if I may, I got this comment during our break. Please try to get like 2 to 3 inches from the microphone.
My question just has to do with not complying with the order, where Mason missed some of the dates of the order. If we missed those, we're required to engage an entity to evaluate merger with the neighboring utility or feasibility study. Why did we not, or we're saying now that we don't want to do that, even though it was ordered by the.
Actually, this question maybe you still have to answer, but we're working on it because honestly, I took over the office over 10 months. And during this 10 months ago, we did a lot of changes, a lot. And with support of the comptroller office and support you, we appreciate you. And we did a lot of change. Financially, we a little bit way above the water right now. And for the study, we're still working on it right now because we have a serious issue for losing pressures, water stuff. The end of the day is we got this company, Alliance, they care about all this problem. We don't have this issue anymore, but the next step is we're gonna take care about all the study about it, and it's gonna cost us a little bit money, but we're working on it. And I appreciate it for understanding our situation because we're coming from a lot of stress, and we hit it in the right direction, honestly.
I guess, and maybe I didn't phrase the question accurately. With the order, if you miss the deadline, you were ordered to engage a third-party entity. So why did you not engage a third-party entity?
Actually, like we try to get the right people to help us to do the study. And also I talked with our engineer, Mr. Rico Oakley, and he's still working on it. I apologize, we don't meet the deadline, but we still working on it because we have a different issue to take care of it. But we're gonna working on it because we have different issue we was there.
Thank you, Mr. Chairman. Are you saying that you're talking to an entity about doing that?
Yeah, we work,
things.
we working on it. We working on it, but I think we got a letter, we showing we're gonna be in compliance with the study by the December 31st.
But have you specifically engaged them?
Yes.
To do a feasibility study?
Yes.
No. They've been the TAUD has been engaged to do a rate study, not a feasibility study. So the December 31st deadline he's referencing is for the rate study.
Okay, and again, we're just trying to get at answers here.
Yeah.
I'm not here to jump on you. How come you've not specifically engaged someone to do a feasibility study? Or is it because you don't want to? Just tell us what you're thinking.
Yes, sir. I'm Laretha Harrison. I'm the town recorder for the city of Mason. So we've got a letter. It's been kind of back and forth. And it's like a feasibility study that we're supposed to be coming together with. We've got an email from a Mrs. Kane. I think do you have that? I've got it. Mary, you got it out
That's
there.
regarding the rate study as well, though. And just for clarity, the feasibility study we're talking about is regionalization of the area for water and wastewater operations. That's what we're talking about. Right, so.
Yes.
So we're talking, I think we're still hung up on the rate study, which should be done by TAUD by the end of the year. Feasibility, I know this is not my position to speak on this, but sat through many board meetings at Mason over the last few months. There were several attempts to get something worked out with Poplar Grove. There was another community, Somerville, I believe, that there were some communications with. But with the deadlines that the Board of Mason were under, they were trying to work something out at Poplar Grove, but the communication coming back to Mason was continually, we'll talk about it at the next meeting. Well, that doesn't work for Mason, which is under a strict deadline. And so that deadline came and went, waiting on communication with other entities local to Mason. And that's why Alliance came in mid-September and signed the contract with Mason to start in mid-October. Knowing the pressure the town was under, normally we would ask for November start, to give us more time to get personnel in and get things ready. But we did come in at least a couple of weeks early. Actually, we did some work for the town a couple of days before we were actually supposed to be there. Came in and started running the water. So hope that has a little clarity.
Well, I appreciate that, but let me be as specific as I can. I know you may be talking to other entities. I understand that. I respect that. But why have you not specifically engaged someone to do a feasibility study? Because that's what the order was.
We began working on it. We had a turnover in our office from our financial consultant, Mrs. Marshall. Mrs. Marshall was working on it, and then things happened and she's no longer with us. So now Mrs. Huey, Rhonda Huey, has been working with TAUD back and forth. And then that's what I was mentioning about the email that was received about, and that was dealing with giving more time. And I think that was concerning the feasibility study.
Just point of clarification, TAUD does not do feasibility studies, though. I think we're still talking out.
Well, maybe, excuse me, I
Oh, no, you're
apologize.
fine.
Maybe
No.
it was the rate study.
Yeah.
I'm sorry.
Yeah, so I think what we're asking is, or that this order said you need to go find a firm to do a feasibility study for you. And it sounds like y'all have not done that yet. Is that correct? Or have not entered into
We haven't, I would say we haven't entered into it, but due to the emails that we've received, it's like they're giving us to December 31st. I've got the email. You gave it to Mr. Cologne.
For point of clarification, I still think that's the rate study. I think what you're being asked to do, and the order, sounds like there's some confusion. What the order is asking you to do is to engage X, Y, and Z engineering firm or whomever that has expertise in evaluate mergers or whatever was best for your customer base engage them in a contract that will meet the intent of this so that they can start evaluating your options.
Yes, sir.
What you all need to do.
So specifically, for a feasibility merger study, I mean, it can be a part of another contract. I'm not saying that, but I mean, there's got to be the engagement, as my colleague says, of someone or some entity
Yes, sir.
to do a feasibility study for a merger. Doesn't mean that's gonna happen, but the order is very specific.
Yes, sir.
Is what I'm trying to get at. You understand?
Well, we're working, we're working toward it. Yes, sir.
To answer your question, honestly, we change in hand, like Ms. Loretta, she mentioned about it. And right now we're gonna back on it because we have a little different personality, different people. So right now we're in the right track. We're gonna work on it back. Just the board give us time, we try to finish it up as soon as possible.
Yes, sir.
Mayor, is there someone that in your office that's directly assigned to resolve this, to make this happen, or is it a group effort?
Actually, it would be,
Pretty much finance. Mrs.
Finance,
Huey, Mrs. Huey has been working back and forth via email, via some information that has been presented. And that's why I was speaking of just kind of back and forth. Nothing is set in stone per se. They're working toward it, but with that letter, I mean, that email chain, but we're working on it. We're working on it.
And do you have I know we talked about our future meeting, but do you have like a deadline of if whatever type of thing you're doing right now? If it doesn't work, you're gonna pivot to another path, because working on it is, it's not, Mason has been in front of us for a couple of years now, at least from what I've said. And you've had various issues that been presented to us and made the news. So what is a deadline for you before you say no, yes, or, because really you probably got to have some deadlines for yourself to make sure that this is being done. Because you'll just keep coming back here, we'll keep having the same discussion. Mr. Pell, is that clear? I'm sorry.
Yes, sir.
Okay.
So, I think for a couple of points of clarification, please correct me if I'm wrong. With respect to the order, there were about 3 primary points, 4 if you counted the delivery and expense. One was engage licensed water and wastewater, licensed in the state of Tennessee operators who are capable of operating the system. And y'all engaged in line. Is that correct?
that's correct.
You were ordered to engage someone to do a financial study, do a rate study, and then make sure your rates were sufficient for revenue. Y'all engaged TAUD. That will be due by December 31st. Is that correct?
That's correct.
The other portion, and I guess this may be a question to Seth, was the mayor and the alderman subpoenaed here today for failure to engage someone because they didn't complete the feasibility portion of the order? Were there subpoenas issued for today?
Yes, sir. Yes, they were.
And is everyone here?
Everyone is here except for one alderwoman, Mrs. Tolliver. Shantae Tolliver is absent today.
And the subpoenas were issued because Mason did not either retain the certified operators or engage someone to conduct a feasibility study by the September 1st deadline. That's why the subpoenas were issued.
And I guess that's where I think the question that myself and Mr. Perky have asked. The not meeting the deadline for the specific order of engaging someone for the feasibility study. Is there a reason why that did not happen? Break that down to its basic
Isn't
question.
this what happened? Because we changed the financial team, we change it, and we change it, take time, got somebody else to take care of it. So everything, it should be good with Ms. Huey. She have the ability to finish it up.
Did you all communicate that with board staff, that the reason for not completing or meeting the deadlines? The feasibility study, have you all communicated why you did not meet the deadline with board staff?
No, sir, I can't say that we did.
Okay.
I'm sorry.
When did the finance team change over?
The finance team changed over let's see, we're in October now.
February.
So it was back in.
February. Ms.
last-
Evans should take over.
Last year, I'm thinking that probably in the, seem like it's around maybe June, July, something.
So.
That with Mrs.
She Marshall left over. Yeah, but we hire Ms. Evans, she took over in February.
Yeah, Miss Evans came on board. Well, shortly after that.
It was last
and then
year in October. when
So
we changed hand.
if you had told me 30 days, that's one thing, but it's been a year. And candidly, it's a 30-day process to get someone on board to start at least, a one-page contract agreement to go through a feasibility study. So who is your engineering firm, or do you all have someone that helps you with your engineering?
Yes, sir, we do. Mr. Oakley,
Okay.
Mr. Ricky Oakley with CEC.
Okay, have you all had conversation with him at all about this?
He's aware. Yes, sir. He's working, as a matter of fact, he was going to be here today, but due to, a family situation, he wasn't.
Mr. Chairman, just a couple of clarifications. And I think we've got other interested parties here also. So, are you the mayor of Mason?
This is correct.
Are you former mayor of Mason?
I'm the former vice mayor.
Former vice mayor, okay. I just wanted to make those clarifications, but I understand, I was a county mayor myself for 16 years. I understand in a small incorporated city where there's a lot of part-time things going on, things are difficult. I understand that. But all you need is an email from a firm. Maybe that firm or some other firm saying that you're going to engage them in a feasibility study to merge, a possible merger. That's all you need. That's separate from these other things. I think we're getting lost in that specific reason that you're here today with the other discussions. I mean, we understand improvements have been made. You made a lot of improvements. We're happy about those. But we've got to stay on track here. The town does, the utility, the board, we've got to stay on track. And the way to stay on track is to make these things happen in a timely manner. So it would have been wonderful if you had appeared today with a one-pager that you had engaged someone to do a feasibility study merger. I mean, are we on the same page with that?
Yes, sir.
I'm in the same page. I understand exactly what you're requesting, but like you mentioned, you were the former mayor, and there's a lot of work, did you know? And be honest with you, for 10 months I have been there. I just wear too many hats. I do a lot of jobs I don't supposed to do. The end of the day is we have a lot of change that happened in Mason for the last 10 months. Meaning is our account, it was in the red before I take. And right now we have a positive account in the bank account. Last April, I put $600,000 in CD, and it never happened in the city of Mason. So I was focused about finance, got every department in order. And we did a lot of change, but I apologize for the study because I was focused about the situation, what we have in the city, because I correct with my team, correct a lot of stuff that never happened before. With the help of comptroller and the new team, what I got, so we're in the right track as we speak. Right? So I appreciate it. They understand what I'm going through. Did you know? And they work with us. Thank God we have alliance with us in the right track. We have a great pressure right now for the citizen. We provide good water and sewer system. So everything is in the right track as we speak. If you give us a time frame, like 6 months, we can finish this study. And after that, should be everything is good.
Mr. Giles.
I'd like to make a motion that, yes, ma'am.
If I may, to address what you guys was asking, the question about the feasibility. It's not that we didn't attempt to do the feasibility. There was a misunderstanding. What happened was you guys sent the letter saying that we had to do a feasibility. If I read it correctly, because I read it 2 or 3 times, we had to do the feasibility if we did not hire a certified operator. So we got the certified operator. So after that, we thought once we hired the certified operator, we didn't necessarily have to do the feasibility. So I think the confusion was they kept going to December because that's actually what the rate study is. So that's where the problem is, but it's not that we didn't want to. That's not the issue. We were going to, but we end up hiring someone based on your letter that we either hire someone or we had to do the feasibility to merge with someone. But we got somebody, we got Alliance. So once we got Alliance.
And when did you engage Alliance?
Sir,
And when did you engage Alliance?
in October,
What's the date?
the 16th is when they came on board.
And specifically, the order was to be engaged by September the 1st.
Right. We didn't meet that deadline, but the letter didn't tell us that we didn't meet September the 1st. That is true. But I just want you to know not that we denied trying to do a feasibility. It's if I heard it correctly, it was that it was stated we didn't want to.
Well, I asked the question. I just.
Yes, sir.
I'm just trying to get where your thinking is, in an honest, open way.
Right.
About how you feel about it.
Right.
I didn't mean to say you don't. I was just trying to see if that could be one of your reasons. You just don't want to.
Right.
So that's what I was trying.
Well, if we, now that we have Alliance, we have somebody, we don't feel that we need to go ahead and do a feasibility to join in with another company. If that's what you guys are requiring still, then we need to be made clear to us that that's what you want to do.
Mr. Giles.
See?
Yes, ma'am. I do. I completely agree with you. And that was actually the motion I'm about to make.
Yes, sir.
So I'm gonna make a motion to this board, since T-Board is a new organization and there's a lot of information coming in from the past, that we give Mason 45 days to enter into an agreement with an organization to do a feasibility study. That will give you time to do it and a time for a council meeting to approve it. And then after the 45 days, 6 months to do the feasibility study. That will get us into spring. That gives you time. You have clear clarification of what we're doing. So, yeah, feasibility of merger. You need to, I'm gonna make the motion. You need to enter into an agreement with a qualified firm to do a feasibility of merger within 45 days.
Thank you.
Okay.
Speak
Thank
just
you.
real shortly before you make that motion, sir.
Sure.
So if the city had engaged, so the city engaged Alliance
Mhm.
2 weeks into September, I'd say. So they were 2 weeks late meeting that deadline. Had they signed a contract at the end of August, would they still have to do a feasibility study?
Yes, and here's my rationale with that. You may be the end solution, but I want to, because of the history, this is the best option. I'm not saying you merge, I'm saying we evaluate as part of a study whether or not you merge. Yeah, we're not telling you to do anything other than bring us information so we can determine what is best for the customers. And so Alliance may be the very best option, but there's a process that's been established and the process needs to be complete.
In my opinion, when I read the same letter y'all got, I can see how you could misinterpret it.
Right. Yes, sir.
That if we do this, we don't have to do that.
Right.
That's the reason I'm making this recommendation for 45 days to just get a one-page email saying we're in an agreement to move forward in the next 6 months.
So
Appreciate it.
if I may, ma'am, I just clarification. You are asking us to do it, not that we have to, it's just to say be sure we got another one just in case or comparison.
I'm making a recommendation, you do it.
No, I'm saying we have to do the
You don't.
feasibility.
Yes, ma'am.
We
I'm,
have to merge.
no, ma'am, that would be at some point in the future, if it's proven that there's some better option for your customer base than what is available through Alliance, at that point, that would be a separate issue that this board would evaluate. But no, I'm not recommending at all that there be a merger, just a study. In 45 days, you have an agreement in place showing the board that you're serious about evaluating.
Just to be clear, could you restate?
I don't know if I can or not. Yeah, I'm not real smart. I make a recommendation that within 45 days, you enter into an agreement with a qualified firm to do a feasibility study for merger.
That's correct. Thank you.
All right.
Due to us 6 months from now?
Yes. So by April 1, how about that? I don't
That's
know what
great.
the date is. By April the 1st.
Thank you.
We have a motion and a second. And
that
that's
is-
perfectly fine for discussion.
Just the fact that. Does that need to be, the fact that the engaged licensed operator is sufficient to waive that? I would not want us to be inconsistent.
Can we get a clarification? I think I heard that she was trying to get here. Is that correct?
She is, she's on her way.
That's the reason I heard that in the background.
She's trying to get.
And it was just the one that is not here.
It's just-
I just don't want us to be inconsistent.
I heard it in the background, so I said that.
Correct.
Yes.
So we do have a motion and a second. Any further discussion?
A question from council.
Yes.
Before we take a vote on the motion, do we want to give staff some sort of authorization to grant an extension on the deadlines if, for good cause shown, if necessary?
Yes. I would on the delivery, but not the engagement. I would on the delivery, but not the
Yes,
engagement.
on the delivery, we will give staff authority to offer an extension, but not on the engagement, 45 days.
An extension of, one extension of up to 90 days is what
It's
we
fine,
typically do?
whatever. Yes.
All right, we have a motion that has been seconded for, and I don't know if I can get this. 45 days to engage the feasibility study with a April 1st due of the study, with the staff having the authorized to do an extension up to 90 days with proper documentation. All those in favor? Opposed? That motion passes.
Thank you.
Thank you.
all. Thank you.
Thank you. Appreciate it.
Chairman, if I could, before we move on,
Said that because we do need to be consistent.
Yep.
Mr. Moody, if I could, before we move on,
Yes.
I just want to reassure the folks from Mason, there's a process in place before the board orders any kind of merger. It's not just a simple, the board discusses it and votes. There are controls and checks in place before that goes forward.
Right. Next, we are moving on to the Hallsdale Powell Utility District. Hallsdale Powell Utility District has been placed under administrative review. This is one of the more unique cases because we generally don't deal with utilities that are, making a whole lot of money and their rates are considered too high. We deal with the ones where the rates are considered too low. And so board staff went and visited Hallsdale Powell Utility District, and they have been great to work with. We've had no issues out of them. They've complied with every single one of our informational requests. However, board staff doesn't necessarily know how to move forward. We have concerns about affordability for customers in the district, considering the plans for Hallsdale Powell in the long run. The one thing that I really want to highlight to everyone is in fiscal year 23, they reported roughly $170 million in long and short-term debt. And they're looking at getting another $65 million for wastewater and $46 million for sewer or for water. That is going to bring that debt load to an excruciating amount that is going to be very burdensome for the customers for a long time. However, problem is these are projects that have to occur, right? They're not just, doing things that don't need to happen, in my opinion. However, I don't know if they're cost effective, right? So board, I'm at a point where I'm trying to make sure that the ratepayer is being protected, and that the utility is, valuing, the idea of affordability. So I just don't, honestly, I just don't know how to move forward with this one, board. And so I'm really relying on you all to help come up with some ideas on the best way to move forward. Because they have Raftellus that we've used their rate studies before. They're a very, reputable organization saying that, yeah, these rates are accurate, but the rates are probably accurate based on upcoming debt loads, and capital improvements. So, board, I do want to completely stress, it says it earlier in there, there is no concern for any fraud or anything like that. All the money's accounted for. We know where it's all going. That's not what this is about. This is about just planning, honestly. So with that, there are representatives from the Hallsdale Powell here today. If you'd like to hear from them, or if you'd like to ask me questions directly as well.
Let's start with questions for Ross.
Yeah. So I just did a quick search on the comptroller's website, and there was looked like they previously had a rate protest before.
They did. So that was under the other board, so under the other board. So there were customers that put together, it wasn't the petition, whatever mechanism it was from the filing in the newspaper, they can submit a rate protest. And essentially, representatives from Hallsdale Powell and Raftellus came to say, we didn't just pull these numbers out of the air. Here is the actual rate study that says, here's what the numbers should be.
Yeah. And the board basically said, we recognize their high rates, but with all the projects you've got going, we can justify the rate. Even then.
And we determined that the board's role was to deem the rates fair based off of the debt service.
Right,
I mean, that was our job in that, and we did so. We had there was no other latitude, if I remember correctly.
And so again, this case came up because we continued to get more complaints about it, and we were curious if there was anything that can be done. And, the one thing that I want to highlight is the over $100 million worth of debt that's going to be coming up in, honestly, a few years. I think it was within 5 years.
On the drinking water side, they've got 71,000 customers. So they're not a tiny.
No, they're not a tiny utility by any stretch of the imagination.
That's a lot. I mean, if you divided that umpteen million to 71,000 or 71,000 to empty.
Right.
How much is each one going to be paying?
I don't know off the top of my head, Tom.
Well, I don't either.
Yeah.
But I'm curious, what are the rates?
Sure. I can pull them up.
And how do they compare, Ross? I mean, I've heard somebody say that they were high. Are they substantially higher for districts of their size, or, where does that fall?
If I recall, they were for districts of their size. That's the main key there. They get to experience huge economies of scale. They're one of the largest utility districts that we have in Tennessee. But if you just give me 1 second.
For comparison, Nick, I know your Metro, Bruce, your Knox, bigger utilities. Mine's economy scale is nowhere near that. What's up kind of rates Memphis, Knox got, I can ask?
So many different ones.
No, we don't.
Yeah, we got so many different ones.
I think it's dangerous to apply, I'm always very careful about applying my rates versus yours. I mean, you can do some comparison with different variables, yeah.
Sorry, good question.
Sorry, yeah.
I guess I was just trying to understand,
Here we go.
I mean, whatever they need to service the debt, they got to service the debt.
Right.
We all agree with that.
Is this infrastructure that's being rebuilt, or is this expanding infrastructure?
I think that would be an appropriate question for
them. Yeah.
Yeah, sure. So if you'd like, board, they're here to answer questions like that. If like.
I think that would be appropriate.
Yep.
Thank you, board, staff, for allowing us to speak.
I'd first like to just give you a background. I think I hear a lot of things, comments being thrown out there, but all of us in this room that are part of utilities know the struggles and trials. I was back here in July, I guess y'all had a meeting, and I listened to every case y'all had, and you know, some of them tug at your heart because it brings back memories for me over 20 years ago coming in. A lot of those people coming in, like today, you got a mayor coming into a system that was aging and dilapidated, and it's not those people's fault and councils. So we were kind of that way. You know, we had new staff, new boards coming on 20 years ago, and over 40 years of deterioration and different types of pipes and materials were put in. You know, it's the best thing I think the utility had at the time, the knowledges that were had at the time. And anybody that's traveled through our communities north of Halls, north of the city there, you got Halls and Powell communities have been explosive, along with large parts of Knox County. So when I first came on, I was field technician, field supervisor for construction maintenance departments. So I was out boots on the ground every day and night, 2 and 3 in the morning a lot of times. We had a lot of areas. Folks in our areas didn't have water at times and low pressure. That was because of undersized plants. Water plants were undersized, booster stations. And a large part of the distribution system was undersized. So we had a lot of issues, a large number of leaks. Our guys and folks out in the field, they would work 6 and 7 days a week, all hours, and I was right there side by side with them. And that's something that we try to relay to our customers. You don't know until you walked in the shoes of that, what a system's really like. The sewer system was no better. The plant violated monthly for nitrogen, ammonia, all kinds of violations. We had hundreds of violations every year at our wastewater treatment plants. We had numerous SSOs that would go unlooked, and management at the time said, we're going to start finding the SSOs. We're going to start figuring out how to fix them. So we started Endeavor, basically engaging multiple engineering firms to go out and let's collect data in our systems, look at water and wastewater systems and see how we're going to best serve the communities, because we were not. A lot of times, like I said, there was areas of our summertime people didn't have water or very low pressure. So we endeavored a lot of engineering sources and folks that could help us lay out a plan. And that's what we did starting in the early 2000s, is laid out a plan. We knew with that plan it was going to cost a lot of capital dollars, so we put capital dollars through that. And then we said, well, we got to have a financial plan. So that's when we engaged Ralph Tellis. At the time was probably one of the premier ones around that we can find that really was in it. They do over, got thousands of clients from the East Coast to the West Coast. The sewer system in 2004 got put under its first consent order. So all this starts becoming regulatory driven. Everybody in this room, and I think most of the people on this board can respect it. Regulations start stepping up and says, hey, you got to fix these things. We got our first consent order in 2004. Said you need to get the wastewater treatment plant fixed, and you need to have mapping. You need to have a CMOM program. You need to have a sewer overflow response program. You need to have everything data logged, and you need to investigate your system. Because what do we all know? The over 680 miles of water pipes, over 400 miles of sewer pipe are buried underground. So we don't have the luxury of just saying we know where the problems are and those kind of things. So you have to go out and figure out how to find these problems and issues that are underground, out of sight, out of mind to your normal ratepayer until it becomes a large rain event and it's spewing out in their field or in their backyard where their kids play. So we were on the news many a times through these years of, they got this sewer overflow and they need to fix it. So the first consent order, we tackled it. We did a lot of investigation, started sewer rehab. did all that work, closed that consent order out. TDEC issued another consent order in 2014 saying, okay, we're gonna move towards the finish line of, let's try to get the sanitary sewer overflows taken care of. Because we were averaging over 100, right at 100 SSOs for a year. So that's been the endeavor we've been on these last path of these 10 years, is to tackle sanitary sewer overflows. Now, when you look at a system our size, you got over 400 miles of sewer pipe and we're very linear. We got one sewer plant that sits all the way down at the end and everything's got to get to it. It's kind of like a big tree. So root balls down here, you got the trunk and you got all these little branches. Just look at a big oak tree sometime and just look at it and think, man, it's got to all get down here. And that's kind of what we were faced with, is how do we tackle that? And so we've been tackling those endeavors and working with the professionals and trying to do that. And so we've been very successful in that. And sanitary sewer overflows have been going down. The plant flows have went down considerably, especially during the dry weather. Our average dry weather through the summertime would be somewhere around 7-8 million MGD a day. Now we're down to about 4.5 MGD a day. So when you look at those dry weathers, when we look at data sets, and so we're seeing a lot of improvements in the system. So in the water side, so we started on this endeavor, the state kind of started looking at, okay, we got to look at unaccounted for water loss, which is really the reason we got called here, right? It was unaccounted for water loss. It wasn't really an administrative review at first. It was like, well, we got unaccounted for water loss that triggered it. On the report was 46%. We went back, gave them a report and said, hey, we're going to do a deeper dive into that. And good thing we did. The number wasn't really 46%. It was about 41, 42%. And that was for FY22 for us. FY23, it dropped down to about 40 point something. And we just reported this FY24 is 38 point something. And today we're tracking along about 35%. Now that's non-revenue unaccounted for water loss. Now that's not including if we actually are probably one of the few that track all of our flushing. We meter that water that we flush out on the ground for water quality, because guess what? We all know in this room that we got to meet these water quality standards. But when I leave my plant and I drive 30 miles or 20 miles out to the other end of it, I'm probably going to have some water quality issues if I ain't flushing water. I got to meet THMs, HA5s, and a lot of, you got to have chlorine in the system when you get out there. So we looked, we track that, but that's not counted. That's non-revenue, right? But if we look at that portion also, that's about another 3 and 5% you would knock off that number. So then you're getting down below roughly 30%. If you're wanting to look at percentage. And we look at it as a holistic approach. So we're looking at what is the cost of that actual water versus try to track it down and attack it capitally, because you can spend $10 million trying to get 2 or 3%. And so we look at those numbers constantly. So water quality is a big one we combat against. And I think everybody probably is combating against trying to keep their water qualities up. So as we look at that, the system, our production and pressure we've worked on. So we've basically tried to lower our pressure zones, which is lowered. We've got over 40 DMAs out in the system. So that means we've divided our whole district up and we're monitoring it through 40-something different meters. We have our own boots on the ground leak detection folks that are out, boots on the ground, actually leak detecting. We did satellite detection. We did third-party leak detection. So we've done a lot of leak detection, which is starting to really pay off. And so the next thing, okay, I'm finishing up. My last point is the financial piece. So, when we came in, we didn't only have to fix the capital, we had to fix the retirement plan, which was massively underfunded. We had to fix the inventory, which was a mess, work order management. So rates, we do track rates. We do affordability studies. And believe it or not, we look at surveys. East Tennessee Development District Survey of 2023. There's 19 other water providers in East Tennessee in that 16 county area that are higher than Hallsdale Powell. And there's 13 sewer providers higher than Hallsdale Powell. I've got a neighbor there that's much, much larger than me that's, we won't speak of who they are, but they're much larger than us. And their rates are, if not higher, or right the same as Hallsdale Powell. So when you want to talk about rates, I think Bruce mentioned something earlier that you got to be careful. You got to compare apples to apples. And you got to look at our system and what we have to do versus what somebody else has to do. We inherited this system. We had to fix it. And that's what we've been charged and responsible to do. And financially, we take that very serious. But I think differently, we've had some constituents through our community that have wanted to keep raising this topic. And unfortunately, they don't want to come get educated. We have offered, I've had board members offer certain constituents say, come get educated, let us tell you. We're very open book. We allow our customers to come ask us questions, show them anything they want to see.
Can I ask you to restate your name and position just so we'll have that?
So
on
my
the
name
record?
is Darren Cardwell. I'm with Hallsdale Powell Utility District, and I'm the general manager.
Do we have any questions from board members?
Just
Tell them.
clarification, I think it was something that Tom said. Number of customers?
A little over 32,000 customers, which he's right. We're probably bumping close to 80,000 people population now.
Okay. And I just pulled up the audit there. It says almost 33,000 water, 25 sewer. Does that sound right?
Yes.
So combined, almost 58,000.
Yeah.
Service.
Things we have to deal with. Yes.
Any concern that you have, if you add another 110 million debt service to 170, you get carrying a debt service of 280 million, which is far greater than any number that I have to deal with where I'm at.
Yeah.
But you're bumping $4,900 debt service per customer then.
Correct.
At 58,000. What does that?
Affordability.
Right or wrong there, but affordability. What
Yeah,
does that
we're right. We're
kind of
kind of in
fall
the
under?
middle of the, if you look at when we have our financial folks run that, there's formulas from EPA now. So we're kind of right in the middle of the box. So we're not too high, not, we're moving, we've moved, but of course the inflation target has moved in that target too. Granted, we wouldn't have had to take a lot of that debt on if they would have let us run a different schedule or a longer schedule for some of our projects. Like the wastewater treatment plant, that was a little over $50 million to get the wastewater treatment plant to the point of producing pristine water. So that's a lot of where our debt was driven is from and we don't only have that. I think all of you probably deal with, we have a number of roadway projects that just have tore us up. I mean, major TDOT projects, and we've dumped over $20 million into road relocation projects. So the customer forgets about that. You drive down that nice 5-lane road with 2 sidewalks, but the state or the county that your residence in says you got to get out of the way, and we're not reimbursing this time. So the utility ratepayers had to pay for those road relocations. So that's another part of that debt. So but we are very aware of it, but we're also very aware that we do look at the folks around us and the perceiving that some of our customers may give is that we're way higher than anybody in the state. But that's far from the truth if you look at the data, and I got the data all day long. We can sit and look at all of it.
Any further questions from board members? Thank you very much for being here.
Now the question stands, board. Do we have a concern about the future affordability, seeing the rate increases that they have planned and the debt level that they plan on carrying for this system? Or is it something that we just continue to monitor? I I really just don't have, I don't know what I would recommend.
Question for clarification, maybe it's a legal clarification, I think. Even if you have concern, what do you do with that? I mean, you have a 3-member board that's appointed through due process by, or through the state, who oversees a manager, and a manager oversees the staff, and the checks and balances there. They've done nothing wrong. I mean,
And if customers complain, couldn't, I mean, they have access to the monthly meeting to come show up, complain, be on the agenda and speak with notice and request.
So what legal
That is
recourse?
correct. We post our meetings and they're able to come to them. And the largest constituent crowd I had was what, 13, 3 months ago. So
I'd like to make a comment, Mike. We were about to issue a lot of my utility is, and our municipal advisor provided us data of comparable utilities across the state, and Hallsdale Powell is one of them. There are 2 in Middle Tennessee that are higher than they are of comparable size. I don't personally have a concern with the rate structure itself based on the debt that they have. And I understand regulatory overrules finances. I would be a little bit concerned about the volume of debt that they're looking at in the future and the impact on the rates, but they may not have a choice. I don't know. I'm not intimately familiar with your finances. I'm gonna go folksy on y'all, like I do from time to time. People don't mind paying $150 for a cell phone, but they won't complain about a $30 or $40 water bill. I mean, we get that all the time. So not only Bruce has got the most valid point, legally, I don't think we're empowered to do anything. But beyond that, this is my opinion. I'm not concerned with where they're at today. Mr. Perky.
Mr. Chairman, I'd note for the record too, that it says staff did not find any evidence of fraud, waste, or abuse occurring at the utility that has led to the utility's current financial position. So.
There you have it.
So with that board, sounds like the board's position is that there's nothing further to do with the Hallsdale Powell utility.
Legally, can you speak to?
Yes, there's no finding, if they're not in financial distress, and there's no finding that there are any financial, technical, or managerial concerns, I don't know that the board would be empowered to take any action.
Yeah, so.
We'll just continue to monitor.
Okay, so then I guess the staff recommendation is for us to close the case, and we'll just continue to monitor the progress of Hallsdale Powell Utility District.
Chair Knight, move to accept staff recommendation to close the case and monitor in case there were future issues.
Motion to accept staff recommendation. Second. Properly seconded. Discussion. All those in favor?
Aye.
Opposed? Motion carries.
All right, moving slowly but surely today, board. 153 East Sevier County Utility District. I'm sure y'all remember those folks because they've been at pretty much every UMRB meeting, the T-Board meeting. eScud has recently engaged TUA to be the new contract management for the Sevier County Utility District. We are very pleased with that decision. We think that's going to yield success for eScud in the long run. Since we last met, if you recall, Witt Utility District was the contract management for the East Sevier County Utility District. However, that engagement is no longer going on. So TUA is at eScud, and in speaking with counsel for eScud and Jackson Thornton, their data is just so bad. There's no way that Jackson Thornton's going to be able to put together a good rate study anytime soon. So it's going to take TUA getting in there to correct all the data for. So we just want to extend out when everything is due.
Move to accept staff recommendations.
Second.
Motion and second to accept staff recommendations. Discussion. All those in favor of the motion?
Aye.
Aye. Opposed? Motion carries.
All right, now we're going to get started with the East Tennessee cases. Hopefully these should go pretty quick. So Ben's going to come up here.
Mr. Chairman, before you get away from Ross, I know there was one other case where we had a contested case that come up that wasn't on yours. If it's not out of order, ask for just a brief update on.
Sure. So are you talking about the Witt Utility
The
District?
utility, yes, sir.
So with the Witt Utility District, we were looking to oust 2 of the board members. Those 2 board members have since resigned. And, there were a multitude of issues. And one thing that we were also looking into was the illicit payments that those board members received, even though they never filed their annual training statement. We really believe that they weren't taking that money out of malice. They really just didn't know about the annual training statement that they were supposed to be filling out, just because they weren't advised to adequately by their attorney or management. So we are no longer pursuing them needing to pay that money, and we're no longer pursuing the contested case against the 2 individuals because they have since resigned.
Thank you.
Because we have a case up in there.
All right, Ben, Bulls Gap.
All right, so good to see everybody today. As Ross said, I'm Ben Johnson. Somebody called me Jason earlier. I just want to make clarification. I'm not the comptroller. We do share the same haircut. Okay, so on the Bulls Gap, this is page 156 on your packet. I'm just going to kind of run through these summaries and we'll get right to the recommendations. But the town of Bulls Gap, they were referred to the WWFB for financial distress in its fiscal year 2020 audit after that came out. They are currently undergoing a large capital project. They're hopeful to will bring in more customers. The entity was ordered by the WWFB in November of 22 to complete a rate study. The entity has contracted with the MTAS to complete this rate study, does yet have this rate study completed. Board staff believes that the entity can have this thing done by December of 2023. So we are recommending by December 31, 2023 to have this rate study into us. I've spoken with the district. We feel confident they can do it.
Motion to accept staff recommendation.
Second.
Motion and a second to accept staff recommendations. Any discussion? All those in favor?
Aye.
Opposed? Motion carries.
Onward. So on to page 158 here. We have Clear Fork UD. Okay, so Clear Fork, they've been under the oversight of the TBOR for financial distress. They've had several years of delinquent audits. Most recently, though, they were able to complete audits for fiscal year 21 and 20. We're still waiting on 22, but again, this is a big step for them because, like I said, they've been out for several years without having this information. In December of 2022, the UMRB issued an order for them to contract with a third party to complete a rate study by July 31 of 2023. They did complete a contract. They've got that set up, but they still did not have audits whenever that deadline was, out there for them to have it completed. Without these audits, the entity did not have enough information for the third party to complete an effective rate study. Board staff believes they should provide an additional 6 months for the entity to comply with the Utility Management Review Board order going back to 2022. Our staff recommendations are the entity shall complete any provisions of that December 8th, 2022 order January 31st of 2024. This is essentially a 6-month extension of where we're at previously. The entity also shall provide a completed feasibility study to board staff by March 31st, 2024. Again, there's language on here going back to the subpoena. Should the entity fail to comply with any directive in this order, board staff and council may issue subpoenas for the entity's governing body and manager to appear in person for the board during its next meeting following non-compliance. And then also the caveat of board staff may withdraw or release any subpoenas issued if the entity has complied with this order and there's no other cause to maintain the subpoena. Is there any questions on this one?
Not, I'll entertain an order.
Motion to accept staff recommendation.
Have a motion and a second to accept staff recommendations. Any discussion? Convene. All those in favor?
Aye.
Opposed? Motion carries.
All right, so if you jump down to page 160, we've got Cold Springs Utility District. So this was one, they were referred to the T-Board for financial distress since 2020. The entities provided the board with a completed rate study, but has not provided proof of the implementation of the resulting recommendations. The entity has retained a lawyer to determine the legality of 5 customers that have water rights to the spring that is also used by the entity. Brought this up a couple of meetings ago. They had some kind of weird stuff going on with a few customers that had some different rights going on. Either way, they've retained a lawyer for this. They're also in discussion with the city of Mountain City, potential merger between the 2 utilities. And so our recommendation goes as follow. We would recommend by December 31, 2023, the entity shall provide board staff with proof of implementation of the recommendations of that most recent rate study or a proposed plan of implementation. Also, by December 31st, 2023, the entity shall update board staff regarding its attorney's opinion on whether its entity is in the best interest to pursue legal proceedings to settle the issue in regards to providing water at no cost to its water rights customers. Board staff would also be given the authority to grant one extension up to 6 months of the foregoing deadlines upon a showing of good cause by the entity. Any questions on this one?
Make a motion to accept staff recommendations.
Second.
Motion and a second to accept staff recommendations. Any discussion? All those in favor? Opposed? Motion carries.
All right, so on to page 162, the Cumberland Utility District of Roane and Morgan Counties. This was an administrative review. A little bit of background about them, and I'm just kind of going to go through what we found. So the district, they serve over 4,500 customers. Roane and Morgan Counties, obviously, they have 3 commissioners. All 3 of those commissioners are in compliance with relevant training laws. Currently, the big story about this one was management over there. CUD was previously managed by Ernie Henley. Mr. Henley was responsible for the general management of the district, field office operations. Board staff was notified that Mr. Henley quit in February of 2023 without notice. During Mr. Henley's tenure as manager, CUD had multiple TDEC violations, which included failure to monitor lead, copper, chlorine levels, failure to properly calibrate equipment, and failure to submit installation projects, as well as failure to issue these notices to the public. In July of 2023, CUD hired a new general manager, Mr. Robert Patty. Mr. Patty previously served as manager to Tellico Plains Water and Sewer System. What we understand, Mr. Patty does have them back into compliance. Mr. Moss, you may be able to speak more about this, but what I understand they're moving towards it. I think that, they still have several things that are outstanding, but to date, they are back up to speed with their TDEC orders. Also, along with this, there was some open records violation. We received a complaint back in 2023 stating that CUD leadership had violated the Tennessee Public Records Act by holding closed-door meetings that only commissioners could attend. Based on review of meeting minutes going back to 2019 and interviews carried out with commissioners as well as staff, board staff could not substantiate any of these claims of violations. We have not received any additional complaints related to CUD violating the Tennessee Public Records Act. And if any occurred, are only relevant to the T-Board to the extent that they reflect upon CUD's managerial capacity. So they do have also some water loss that you can kindly see the percentage are an uptick. As reported on their most annual information report, they are over the 40% threshold. We would say that they're not compliant with this, and board staff would recommend that they have a third party come in and complete the AWWA 6.0. Quick section about the rates. The water rates we do have those listed if you'd like to look at them. They're not financially distressed, which is always, a good thing. They've been running positive statutory net position for years now. They do not have plans to raise rates, and they only carry long-term debt totaling $3.48 million. So board staff believes that the administrative review should remain open to more or less evaluate the progress of new management at CUD. I'm happy to answer any questions if there's anything specific thoughts.
Would there be any expectation for them to report in to you or how?
We'll request information regularly.
Okay.
Yeah.
Mr. Chairman, I'd like to abstain from voting on anything related to.
Noted. Thank you.
Recommendation, we accept staff.
Second.
Okay. So to leave it open then, and we'll just, like I said, we'll be in touch with them, just kind of like checking in on them, see how things are going.
All right, so we have a motion and a second to accept staff recommendations. Any discussion? All those in favor?
Aye.
Opposed? Motion carries.
All right. So big jump here to page 272 of your packet. This is going to be Mooresburg Utility District. So Mooresburg has been referred to the Utility Management Review Board for financial distress since its fiscal year 2020 audit was released. The Utility Management Review Board issued an order regarding the entity in 2021 and a new order in December of 2022. The entity has partially complied with the December 2022 order. The entity contracted with Jackson Thornton for a rate study. It was completed in July of 2023. However, the governing body has decided not to follow the recommendations outlined in the rate study. The December 2022 order required the entity to implement the results of the rate study by September 1st of 2023. Board staff has been informed that members of the entity's governing body are present to explain why the rate study has not been implemented. Board staff believes that the entity should begin implementing the recommendations outlined in the rate study. And the board recommendation is as followed. By December 31, the entity go ahead and provide staff with the proof of implementation of resulting recommendations or proposed plan of implementation. With that said, it's okay with you all. We have, like I said, we have members of their governing body here to address you all about this.
I think that's appropriate.
All right.
Thank you all for letting us speak. I'm Joyce Carpenter. I'm the new general manager that's just been elected to Mooresburg Utility. They've had a big change in their utility. Two of their board members has resigned as of the second week of August. Their office manager and one of their office staff had resigned, and their bookkeeper had resigned. So that's just kind of left them with short staff. At the moment, I'm the only one running the office, and we have hired us a new bookkeeper, and we've got two more board members on staff now with us. So we're now back to 3 board members. But with the rate study, they did not get it completed before all these people had left the office and resigned. So we're having to kind of comply with the state and ask for an extension to see if we can go through the rate study and possibly make some changes, because financially, we think we can recoup back some of the money that's been lost by their expenditures of wasted money, where they paid penalties for taxes that they shouldn't have had to pay. And especially on the payroll taxes, they were paying those quarterly, and it should have just been monthly. And so they were paying penalties for each quarter that they paid those. And we found other issues in their finances that they hadn't paid that we've had to go back and pay penalties for that too. So hopefully we can show more generated monies coming in to maybe offset the amount of what we would have to adjust the water rates, because it's just a small utility of just 700 customers. And a lot of those are low income. And we're just asking for an extension at this point to see if we can make a difference financially before we make a rate adjustment.
First, thank you for stepping in and trying to clean some of this up. My question is actually for staff. I find it curious that all these people resigned at one time. Is there any concern about that?
Yeah, so I will say this, I've been up there. We don't have our Department of Investigations legal counsel here, but I am under the impression that they have opened some type of DOI investigation.
Okay. Has nothing to do with you. It just, when I hear all that,
Well,
I'm
no,
like,
actually, we requested that the state come in and possibly do an investigation, or the president of the board did.
okay.
After, before they hired me as their general manager, he had requested that they come in and do an investigation. This also gives us a clean slate to start out with too.
Thank you.
And if
Yeah.
you look at, on like page 273, I mean, they were in the red in 21 of just $12,000.
Right.
And they had depreciation, which we all love, is 138,000 of that. So you got cash in the bank. You're just upside down in your net position. And it's not, thanks, and maybe nominal at this point that you think that you may be able to make up.
Well, I mean, if you look at the fact that they paid out, penalties for taxes that they shouldn't have had to pay if they'd have paid the taxes correctly or even paid them on time.
Do you think that would have been?
Right now, we're at about $15,000 back taxes that we found. And that's just what we have found at this time. I mean, I'm sure there may be some more pop up, but once we get those paid and get it on a schedule to when it should be paid, that should eliminate a lot of penalties that we've paid out.
Well, but you probably won't get those penalties back.
No, you won't really recoup your penalties, but in the community that we're in with the low income, plus we've had a factory to close down, so that hit a lot of the people at the moment until they can, get a job back and stuff. So we're just kind of hoping that for an extension before we do the, rate adjustments to kind of help us out too, to figure out where we're at standing wise financial.
How long have you been there?
I have actually been there since August, but I was only there as a customer representative. I had worked at a previous utility before that.
Can I ask, do you feel like you can meet this December 31st?
I mean, we can try. I can't make promises, overnight, because we don't know exactly what else we're going to come up against, but we really are trying to meet, what the state wants.
Ready for a recommendation?
We'll make a recommendation that we accept staff, what you're suggesting, but with your authority, we give you the authority to extend for 45 days if needed.
I'll second.
All right, we have a motion and a second to accept staff recommendations with the opportunity to extend that 45 days if staff finds it appropriate to do so. Any further discussion?
I hate to just have to always be the counter, but why don't we just give them to the deadline, the first, when are we meeting, the first quarter of 24?
I'm going to be recommending the second Thursday in March. And so in the first quarter.
I'm fine with that. I mean, that's pretty quick. I mean, you're talking about they're talking about wrapping up your fiscal year is on a calendar year, is it not?
Yeah.
Okay. I say extend it to our next first quarter meeting.
I recuse. Full recommendation then to, it's like a March that we, so just say have it implemented on the same language, but just change December 31 to whatever that March date is that we decide on.
Can I make a recommendation? Let's say that they have to have it implemented by April 1. And so that way, if by that time they find that a rate increase isn't necessary, then we can rescind the order at our March meeting. How does that sound?
Perfect.
That's my recommendation for it.
All right, so have you
I
rescinded?
rescind my recommendation.
All right, I'm entertaining a new motion.
All right, if I can get it out now. Okay, I'll make a motion that we extend to April 1, the staff recommendations for implementation.
Second.
Motion and a second to accept staff recommendation. Any additional discussion? All those in favor of the motion?
Aye.
Opposed? Motion carries.
Thank you for coming.
Thank you. Thank you, Al.
Just trying to do the right. Damn, what's the deal for today?
All right, we're rounding it out here. So let's jump ahead to page 336 of the packet. It's going to bring us to the town of Oliver Springs. This was, again, another administrative review. So the town of Oliver Springs, they operate a water and a sewer system in Anderson County. They serve around a little over 2,100 water customers and a little under 1,500 wastewater customers. The entity's governing body, you can see there, is listed below. And as of today, the governing body is not in compliance with all relative utility training laws. Story about their management, as we went out there, we learned, so the entity was previously managed by Mr. Thomas McCormick. Mr. McCormick was responsible for general management of the district, field office operations. While manager, the entity experienced non-revenue water loss exceeding 70%. When leadership became aware of the non-revenue water loss, Mr. McCormick's employment was terminated in April of 2023, and he was approved with a severance package. The town manager position became available, and Mr. Corey Jenkins was hired. Mr. Jenkins accepted the position with a 6-month probation period to determine if he was suited for the job. Mr. Jenkins has satisfied this requirement and is still in the position of town manager. Board staff believes that Mr. Jenkins can improve water loss and work with outside consultants to improve the financial positions of the entity. The water loss situation, again, the entity reported non-revenue water loss of 76% in their most recent annual information report. I've been told by Mr. Jenkins that may have come down a little bit since then, but the entity has provided a non-revenue water loss plan that includes replacing service lines, removing old lines, installing new meters, and that is going to be started in November of 2023. Additionally, the entity is working with the Water Finance Exchange as well as performance services on identifying problem areas, potential solutions, and funding opportunities. The rates, so again, they're financially distressed for 3 years now. They've, I think that's, negative statutory net position of $510,000 for FY 2022. They've recently raised inside water and wastewater rates, and additionally, they are under a board order right now to have a rate study completed by December 31, 2023. Contracted with Jackson Thornton to complete that. Also, the feasibility study, they have an outstanding order for merger potential between entities in their location. Specifically, Oak Ridge is one that's been mentioned, and any other utility system in the area. That's to be completed by March 31, 2024. So when the entity has completed all outstanding orders, there's going to need to be an assessment to determine if there's going to be further action. So with the recommendation, obviously we've got several orders out on them right now, and that's all going to be coming back to us, and that'll be another discussion. But the board should order the following. This is our recommendation that by December 31, the entity shall send board staff proof that all members right now are in compliance with the applicable utility training requirements. And this order also, just to make it clear, would not supersede or withdraw the requirements of any previous order. So again, this is going to be one that we're going to be talking about at the next meeting after they get all the stuff that's already outstanding on them. Let's add on just the, out of compliance with training.
Have they entered into an agreement to evaluate merger with anyone yet?
They have not.
Is there a timeline for that?
I do not think it was specifically stated. That might be something we could address, but like I said, it's just to be completed by March 31.
Go ahead. Mr. Chair, I would make a recommendation that we modify this staff rec to include a 45-day time period for them to enter into agreement with someone to evaluate merger. A qualified firm to evaluate merger.
Second.
All right, we have a motion and a second to accept staff recommendations and adding the caveat of 45 days for proof of engagement. Any discussion? All those in favor?
Aye.
Opposed? Carries.
Tennessee.
Well, board, I came to the realization today that as West Tennessee analyst, I will be forever the last to go. And because of that, I'll try to make this brief. But if you will turn Page 445. That is where the West Tennessee staff recommendations begin with the city of South Fulton. They've been under the board for quite a while now, since 2017 audit. They had a rate study performed by TUA in the 2021 fiscal year. It was completed in July, so just right at the start. However, they missed the projections in 2021 and did not complete the year with a positive change in net position. And then the issue in 2022 is that they split the water and sewer fund into separate funds. Regardless of that, the 2022 year would have still ended negative if you total the two funds. You can find that on page 447 that has the audit. But regardless, now the sewer fund is sitting at a deficit of 230,000 change in net position. So basically, we're just asking that a new rate study is completed that can take into account any changes that have happened, maybe management or capital projects, but specifically the changes in the way they account for their two their water and sewer fund, separate funds. But pretty much the rest of that is just standard. We're asking by December 31st, the entity shall send board staff a copy of the contract by June 30th, 2024, have the completed rate study presented to board staff. And then we have the authority to grant an extension of up to 6 months if we see good cause by the end. So any questions from the board?
Chairman, I move to accept staff recommendation.
Second.
Have a motion and a second to accept staff recommendations. Any further discussion? Dean, all those in favor? Opposed? That motion carries.
Moving along to the town of Gibson. They came underneath the board back in July 19th, 2023, under T-Board, requirements to complete a bunch of different submissions. You can see they're listed out 2, 3, 5, and 6. August 31st, we needed the status of their delinquent audits as well as the status of the interfund loan between the water sewer fund and their general fund. And then the September 30th deadline was for a contract to perform the task in paragraph 1, which I believe was a rate study in that order. And then to also complete an annual information report. At this time, they have complied with the order. And so what I'm looking to recommend basically is if you scroll down or if you want to look at the information that was submitted, I think it should be in there. If not, I apologize about that. But they did send a response to us that was basically saying that we're going to repay the interfund balance. We're going to be doing that in a large chunk at first, and then we're going to split it up into monthly payments or repayments. As for the audits, they're hoping to have both audits completed for 2021 and 2022 fairly shortly here. So my recommendation is basically just that they must provide updates to board staff on a monthly basis as to the repayment of these funds, and that these updates should continue until the requirements of paragraph 2 are completed. We may request additional documentation if needed. And then once the interfund balance has been repaid, we may close those requirements without further action by the board. And then I also have in there for staff recommendations is that if the Division of Local Government Audit is not able to confirm the fiscal years 2021, 2022, and 2023 audits by December 31st, 2023, the entity shall provide board staff an update regarding the delinquent audits by January 31st, 2020. But I have been in contact with the new mayor, who I think came on more recently, and then as well as their attorney for the town, and both seem to be making stronger progress and getting things cleared away. The issue right now is they're working with a third party to complete the rate study, but the third party isn't comfortable starting the rate study until those audits are filed. And since we're 3 years behind almost at this point, that's kind of what we're looking at right now.
On the audits, has the town contracted with a CPA firm for those years, or they are just wishfully thinking that that's going to happen?
It is my understanding they've contracted with the town, and I wish do I have that in the full online version?
We don't have any concerns that contracts don't exist.
Okay, yeah.
Make a recommendation that we accept staff recommendation.
No negatives, a lot of recommendations.
Yeah.
Second that recommendation.
All right, we have a motion and a second to accept staff recommendations. Any further discussion? All those in favor of the motion?
Aye.
Opposed? That motion carries.
All right, last one for the day, and then I'll turn it back over to Ross. The board, or I should say, the Water and Wastewater Financing Board issued an order, I think, back at their last meeting regarding the town of Hornsby for what was called an investigation at that point, now an administrative review. Board staff, we traveled to the town, conducted interviews, we went through documentation supplied by the town. And I'll just run through the report real quick. Board training, they're in compliance with the training requirements. As far as the water operations, it appears most of the issues stemmed from prior management and prior oversight. I will caveat that with saying that some of the board members have been, if you look at the exhibit, some of the board members have been on the board for lengthy periods of time. So they may have 2 new board members, but majority of their board have still been in office since kind of these problems first originated. As far as their water issues, their water loss appears to be fairly low as far as the most recent annual information report. According to the AWWA, though, that was submitted in the 2020, it was a little bit higher, above the 40%. The biggest issue is just a declining customer base. Over the last 14 years, total usage and customer base has declined by about a comparable percentage. Right now, they're they were delinquent on audits as of September 20th, 2023. We received a report from them. The 2024 budget was not filed with the Division of Local Government Finance, and therefore they received a non-approval. I spoke with town board members, and as of today, they still have not adopted a fiscal year budget, is my understanding. They're pretty close to it. Hopefully sometime coming up here in November is when they'll be able to adopt the budget. Other issues were just that they did not adopt or at least maintain records of their policies. Like I said, there was poor managerial and operational oversight. This included things like the second finding there where prior management shut off. To my understanding, the prior management shut off the SIM card that runs or operates the pump that would tell it whether or not it needs to continue to fill. And then that ended up costing the town a sizable amount of money from what the standard month-to-month bill from the town of Selmer. All that to say, and if you have any questions, I'd be more than happy to answer them. It's staff's recommendation that at this time, I did not feel like there was anything currently as far as mismanagement. It seems like they're headed in at least a better direction. They have hired new management to run the system. But I am asking that they go ahead and carry out a feasibility study due to, one, the customer rate declining, but 2, the fact that they don't operate a sewer system and that they don't even produce any of their own water. They're already connected onto Selmer. And so this may be a situation to look into if there is a feasible way to merge utilities at some point. But I would be more than happy to answer any questions that you have.
Mr. Giles.
I've got a question about one of your findings. So it says the town signed formal contracts that allowed for financial exploitation. And I think you said some of these commissioners have been there for a significant amount of time. So are they carrying out their fiduciary responsibility? Because it's not a lot of money, but it's still just the principle of are things being done correctly with the existing commissioners? Or
so yeah, so the issue here is that, from my understanding, the board may never have even been aware of this contract. The prior mayor appeared to kind of take control over the town, from my understanding, after speaking with employees and board members. And so the board was somewhat left in dark. With that being said, something we discuss often with this board is that you still have a requirement and you still have a duty to, as a board member, to be sure of, you know, what is going on in your town or your utility district. And there is some concern there from board staff, me primarily, regarding the current board members and their ability continue simply due to the lack of oversight that was provided under prior management.
Any further questions or discussion? Entertain a motion.
Motion to accept staff recommendations.
I'll second it. Motion to accept staff recommendations and seconded. Further discussion? Dean, all those in favor? Opposed? That motion carries.
All right, board. So the last thing that we have to discuss is the potential for 3 meetings to be scheduled for 2024. The dates that I would like to offer to you all are March 14th. We'll just start there and y'all just tell me if that one works or not, and then we'll work through the other ones. March 14th.
I have a busy March, but that date works.
Awesome. Okay, cool. So March 14th, July 18th,
Yes. I'm tied up. No, I'm good. I'm in the, got an evening one.
okay.
Yes.
Yes.
All right, July 18th and October 24th.
Yes.
No shot.
What was
This is crazy.
In 24.
This is crazy that I got all 3 of those.
Yes.
Yeah, all right.
Say it again, 3 dates. We're not
March
out of time.
14th, July 18th, October 24th.
We'll send this.
Yes, and I'll send calendar invites to everyone.
All right.
Yes, you done. I didn't cut you off.
Yeah, no, I'm done. I ain't got nothing left.
You know, before I make the motion to adjourn, you know, I don't get the kind of the consensus of staff. When you look at this agenda, this is all East and West Tennessee utilities. So by default, would you concur that Middle Tennessee utilities are probably the best in the state?
I would not. I would concur that staff is significantly better in the east. Oh.
I'm not going to comment there.
Run out the door. Strike that from the minutes, please.
Vice Council Ross.
And I second that motion to adjourn, so we are adjourned.